All right. Good morning. Welcome to the subcommittee. We are discussing 3 bills. I was going to go through the easiest one first, what I think is the easiest one, HB 1330. And I have an amendment. This got to do with medical technicians. And let me get my notes. So during the hearing, what we discovered, or what I remember, is that we are the only state that tried to license medical technicians, and those people cannot really do any work outside a hospital, so they need to get access to the hospital, to the rooms, the x-ray rooms, and things like that. And they are always supervised by the doctors, so there's really little point in trying to license them. We had a conversation at the end of the testimony with the OPLC director, and Bill Marsh, who is a doctor, chimed in, and it was pretty much in agreement that this whole chapter needs to go, and that's what my amendment is about. So, any comments, questions? Representative Gawley?
Thank you, Mr. Chair. I just have some concerns of getting rid of this board altogether and the registering of medical techs. I know while this may be germane, it's totally different than what the bill was doing and making them advisory only. And I just have an issue with not holding a hearing on getting rid of them altogether, having it done. I just don't think that's what was posted or that what was noticed or that was in the bill. And this is, while it entails the same subject, it is doing something totally different than what the bill did. And I just can't support this support this amendment at this time.
Oh, thank you. I think it'll be up to the chair to determine whether it's germane or not. So, thank you. Yeah, please.
I understand that, and it probably could be raised as germane, but I just think that this was not what was the intent of the legislation and goes about it in a totally different direction. Thank you.
Thank you. Any more input? That's what I would like to do. I think this is straightforward. Well, we'll be up to the full committee after this. So, oh, sure. I think, yeah. Thank you.
Make a motion to adopt the amendment.
I'll second it.
Any discussion? You want to speak about you first and second?
Less is more.
All right.
Yeah, I mean, it seems like this is what was supported by other members of the committee and OPLC.
Thank you. Any more discussion? Good.
I think I've raised my concerns, and that's the only concern I have about this. Thank you.
Thank you. Please call the roll.
Representative Santanastasso.
Yes.
The clerk votes yes. Representative Goley.
No.
Representative Fellows not here. The chair.
Yes. Thank you.
So that would be 3 to 1.
Okay. All right. So, closing that one, moving on to the next easy one, 1497.
Are you going to do the vote as with amendment, ought to pass with amendment?
Oh, yes, of course. Thank you.
Motion to ought to pass the bill as amended with amendment.
Seconded.
All right. No. If no discussion,
no
please
comments.
call. Yeah, thank you. Yep, please.
Representative Santanastasso.
Yes.
The clerk votes yes. Representative Goley.
No.
Fellows. And the chair.
Yes, please.
3-1.
Thank you. So 1497, very simple change, one line change. There was a concern that something got accidentally deleted from the bill, and does anyone in the public wants to clarify? 1A, 2A, anybody? Oh, all right. Please, please introduce yourself. 1497, yes. Please introduce yourself.
Thank you, Mr. Chairman.
Thank you.
On 1497, the concern we had was a member joining the retirement system or any member. That would leave out the people that are currently employed. So it would have to be current members and members upon joining the retirement system and any member who reaches this service age. So you gotta include the current employees also, which is not included in this language.
So what would you propose the exact sentence to be, the beginning of the sentence, please?
Any current member or members upon joining the retirement system, any member who has reached service age.
Any current member or members? Okay, any current, okay. Okay, thank you.
Thank you.
Mr. Carlin? Yes.
Thank you, Mr. Chair. I think your initial question was about deletion of 85, 1 and 2.
Maybe the microphone. Thank you.
Yeah, and I do have an additional comment on Mr. Beaudry's suggestion as well. But to get back to your original question, yeah, striking out 100A5, 1A, and 2A could open up the benefit to folks who are eligible for early service retirement, but not yet full service retirement, because they're both contained in different sections of A5. So restoring that would basically keep the benefit available to the same pool of people it is now, but just allow, members prior to service retirement to elect it. And then just for brevity, perhaps on the first comment, and I know Representative Pearson brought this up at the public hearing, the upon joining the retirement system could be seen to exclude people who are already in the system. So if that just said any active member, comma, any member who has reached service retirement age, et cetera, then if you're working, you could put in for this.
Okay. All right, thank you. So if you could send me that exact language, please, just email it, and I'll get it drafted. Hopefully we pass it today.
Sure thing.
Thank you. So current or active, pick one, please. Yeah, and just the verbiage.
Active is a better statutory term. There's
Active?
a definition of active member.
Okay,
in statute
okay.
already in A1.
Okay. Yeah, if you could please send it to me, and then I think, right. Oh, please, Representative Gawley.
Thank you, Mr. Chair. And also, can we also, so that we have it in two places in case something doesn't go through? When we do the amendment,
Could you please clarify?
House Bill 1557
Um,
pertains to the same
Yeah,
portion of the statute.
right.
So if we could have that language included in the amendment we have drafted on 1497 to make sure it's in both bills, because if one passes before the other, it's going to revert back to,
Okay. Yeah, I'm not familiar with that bill that much. Was there a subcommittee for that one, or is that, what's the status of
we
1557?
exec it. That was exec to
exec it.
pass, so that's why I want to make sure it's in both bills, because that's already agreed upon language with this committee.
Oh, okay. All right, so we'll get the front of the sentence from Mr. Carlin, and then the tail of it will be right there from the bill, 1557, right?
Correct.
Okay, thank you.
Thank you.
Okay, thank you.
The change is from any member to or any active member?
Pretty much, yeah,
Yeah.
and bringing back the 1A and 2A that got deleted.
Thank you.
Thank you. Okay, yeah. If Mr. Carlin, please send me the verbiage, and I'll include the 50 and 57 language in. I don't think we need a vote. There's
Not
nothing
until we have the
formal.
amendment.
Okay, nothing formal. And I don't think we need a subcommittee anymore. We'll just draft it and bring it to the full committee. Okay. That's it. So I think we're done with 1497. Thank you. So the next one is 1587. So the handout, this handout we just received, would you like to explain it, please, to us again? Yeah.
Thank you, Mr. Chairman. I don't know if you want, for the record, Arthur Beaudry, representing the New Hampshire State Permanent Firefighters Retirement Association. I handed out a worksheet. This is what I spoke about when I testified on the bill at the hearing. But if you look at the page with where it says based on highest 5 years, the first column is prior to July 1st, 2011, which is the old language. So column A, that firefighter worked no overtime. Firefighter B, that firefighter worked overtime in their last 5 years. So firefighter A would get a $20,000 pension because that's their average final earnings. Firefighter B, their average final earnings would have been $25,000, so they would get a pension of $25,000. Then you go to the current language that's in the law right now. Same thing, firefighter A works no overtime. Firefighter B, the last 5 years, they work some overtime. But if you look at it under the current language, they still would only get $20,000, even though firefighter B, for 5 years, put in $25,000 in contributions. They would not get credit for that. So the language that's in House Bill 1587 would be the proposed changes. So firefighter A, again, works no overtime at all, gets $20,000 pension. Firefighter B would work their last 5 years, they would work some overtime. So when you average out their career, they would end up with $21,000. So they would get credit for those last 5 years. It's not as substantial as the old system where they would get credit for the last 5 years and not average out their full years of service, but at least they're getting credit for the money that they put into the retirement system and paid on. And that's the difference. They're actually getting credit for what they paid for.
Thank you. Any questions? Yeah. Representative Gawley?
Thank you. And I just want to be clear that they're paying into the system, working those years right now currently, but not receiving credit for them.
Correct.
Thank
That
you.
would be the middle case, and that's under current law. They've been paying in the system, but they don't get credit for those years.
Thank you.
That's it. Thank you.
Okay, thank you. Oh, yes, please, Representative Fellows.
Can you just go through the steps on the proposed change column?
What do you mean the depth?
The steps.
Maybe the microphone, yeah.
Steps to do that calculation.
Well, we try to make it it's simple. That's why we went with 25 years. So the first 20 years, they earned $20,000. Their last 5 years, because they worked overtime, they might have got promoted and worked overtime. they were averaging $25,000 a year for those last 5 years. Under the current law, those 5 years don't count.
No, that part I understand, the
Yeah.
proposal. So, the proposal says, the percent that's in, it says, refers to the percentage, average percentage of compensation that's the excess.
Right.
So,
Because if you take 25 years and you average all those numbers out, it comes out to $21,000 a year. So those 5 years boost that average by 20%, because you're taking your last 5 years that are not included right now, and now you're gonna put them into your calculation of your full years of service, which would add roughly, under these scenario, 20% into your calculations, which brings you to 21,000 a year.
well,
Am I making myself clear?
no.
No?
Because, so their excess is 5,000. Their base is 20,
Yep.
and their excess is 25.
Cor-
Their
it-
excess is 5.
Correct.
So that is 25%.
No, because you gotta average it over the 25 years. You gotta average all
Oh.
those numbers out over the 25 years. You don't,
Oh. So,
so if you had a
Oh,
calculator and you
okay.
averaged all those numbers and then multiplied it by, divided it by 25, you're gonna come up with 21,000.
because it shall not exceed.
Right.
So if they were getting 25,000 the whole time, then they would, okay.
Yeah.
So it's, the average, it still says average.
Right,
So-
average over
okay.
their lifetime, over their career.
Okay, so if we 1, 2, 10, 20, so 25,000 excess
Right, but you gotta,
divided by 25 years.
divided by,
Okay,
yeah.
okay, now I
Well-
understand that.
You pretty much have to add it all up and divide it by the 25 years. Because that's what the law says, your average of all your years of service, but under the current law, it says excluding your last 5 years. So what we're doing is we're adding your last 5 years in the calculation.
Well, it says service on or after 2012, so we're only talking about 10 years this year and 11 years next year.
Yeah, but there's firefighters out there that, if they weren't vested, they were part of the system. So you could add 9 years on the job. You're gonna be underneath this, so you're 9 and you got 11 years, so you're almost 20 years of service. So these people are coming close to starting to retire now.
Okay, so for the first ones, it's only gonna be, like for the ones retiring this year, it's just gonna be over, it's not gonna be their whole time, it's gonna be over the last 10, 11 years, but then it works its way up, right?
I would have to see their date of service and that, I couldn't answer that.
Okay, thank you.
Thank you.
Yep.
Thank you. I don't know, Mr. Carlin, if you have any more, if you have any insights on this chart as well, or yeah.
I haven't seen the chart.
Oh.
What's the chart from 2018? Okay, I saw this 4
Okay.
years ago. And generally speaking, Mr. Bodry was describing it accurately.
Okay.
How it works. It only pertains to the compensation over your base pay and how that is averaged. Because right now there's 2 separate calculations, high 5 and everything else, and then the lower percentage is applied. This bill would be high 5 versus entire career, so as indicated in this chart, it increases the pension by some degree, but not completely, depending on how the person's salary history works.
Yeah. So the 20% right there. Yeah, maybe you want to step to the microphone. So the 20% at the bottom of the chart, if you have a copy of it, right there, percent of overtime to be used for AFC is 20%. The 20% comes from where exactly?
Okay, so in again, on this chart, you know, the base was 20 and 25,000 was the total, so there was 5,000 was compensation over base in those last 5 years.
20%, yeah.
And actually, wouldn't 5,000 be 25% of
25%.
20,000? But, you know, same principle. Basically, the current formula will take the lower of the two percentages, which is 0 for the rest of this hypothetical career. So they wouldn't recognize any of that compensation over base in their average final compensation. But when you average those 5 years with the other 20, you know, it does actually, you know, add $1,000 to the final compensation, which is a piece of the pension formula. So, that's how that works. It's the exclusion of the high five from the rest of the career is what the current law does now, and this bill would use the high five in both sides of that equation. And just to a question earlier about prior to January 1st of 12, compensation was reported as one line item to the retirement system, so it's all technically considered base. So if somebody has years before or months before 1/1 of 12, that isn't included in the career calculation of comp over base because we don't have the data.
Okay. All right. And any more questions? Yeah, Representative Gawley.
So, Marty, under the current current statutes, we heard that those folks, whether it's in corrections, police, fire, that we see are short-staffed and people are forced to work the overtime in their last years of service, and those hours that they're working are not counting towards the system, correct? Towards their retirement calculations.
You can't make a blanket statement to that effect because it depends on how much comp over base they're earning in their high five versus their other years. If they're earning more in their final, they end up being their high, earning less in their high five because their base salary is up, you know, all of it would be recognized. So it really depends on the salary pattern of the individual. Some people, absolutely, it's going to lower their AFC. Some people, it could be neutral. You know, if the percentage is lower in the high five already, then none of the money in the high five is reduced.
But there are scenarios where this isn't counting towards their final.
A portion of the compensation in the high five is not counting towards the pension calculation. In some cases, yeah, it could.
And one last question. And there is a cap as to the individual can't make unlimited overtime and build up their pension just by working overtime, you know, 200% above doubling their pay for the year to count that towards their retirement. There's a cap as to how much they can.
There is it's been in the books for about 30 years now. There's a cap on the last year of earnable compensation. So when somebody's final year, you know, they couldn't work, you know, 20 hours a day and, you know, make the cap is anything over 150% of the next highest year in the AFC. We can't count towards the pension.
Thank you. Representative Fellows.
What we're talking about here today, is that, let me turn this around. So state workers, for example, get to cash in sick days and vacation days. Are those days, that pay part of the calculation in here?
No, because the using or taking payouts of accrued leave time, sick time, vacation, et cetera, is no longer earnable compensation for anyone who wasn't vested prior to January 1st of 2012. They'd still obviously get the money from the state or from their employer if it's part of an agreement, but the legislature excluded those pay types, you know, unused leave time from earnable compensation. So the people who are affected by 1587, it already doesn't count for them, so it doesn't play into this at all. It's only that those pay types are only for vested members. in terms of the pension.
A follow-up?
Well, it's actually another question.
Okay, please.
So, when I look at the changes that are proposed here as an amendment, I'm wondering if, instead of writing a new separate paragraph down here, C, and what if we just edited line 18 and 19 and just took the excluding the highest 5 off, and it would apply to group 1 and group 2? Would we get the same result for group 2?
If you're not gonna vote on it right away, my initial analysis is yes.
But you
But
wanna
I
read every word?
would wanna, just vet that, with a couple of folks at the office. I think C was added, so there's a distinction between group 1 and group 2 in this bill. So, this bill only does apply to group 2 members as written. So there's, the group 1 population still has that 5-year versus the rest of the career. So initial analysis, yes, and I can, if the committee's interested, I could get you an answer today.
Follow-up?
Well, it's not a question, but.
All right.
But my thought is that, I don't see why we should be doing this only for group 2 and not group 1. I don't understand any justification for doing it differently for the 2 groups. It would cost, I don't know if it would cost, I'm not sure it would cost very much more, because I think that the issue of having all this extra time, overtime, is a lot, way less prevalent in group 1 than in group 2.
Yeah, I couldn't venture a guess on that. Teachers tend to work on a contract salary, so there is not much, if any, comp over base. That may be a coaching stipend or something. Some employees, depending, first thing comes to mind is highway folks may have more overtime opportunities than, an office worker, but, it's a larger cohort of the membership, but the availability of overtime and differentials and things like that is probably less on average.
I'd rather not complicate a bill that's complex enough already. Please, Representative Fellows.
Well, I think that the bill may look more complicated, we could obviously just vote to pass this the way it's written, but in the long run, somebody's just gonna say next year, why are we treating them differently? And that the fact that you've made, two, you've got a distinction between 2 different groups when you don't really need to do that, makes the resulting legislation more complicated.
Thank you. Yeah. Representative Gawley.
Thank you, Mr. Chair. I look at it right now as an issue of recruitment and retention, especially of Group 2 members. We're hearing with police, fire, and our public safety individuals in corrections. We're looking at the easiest way without having to break the bank of doing this. I think if you add everyone in all at once and you see the cost, and Marty, I may be wrong here, but I think the cost, when you add in all of Group 1, would actually add a substantial amount of money to what this fiscal note is currently. That the sponsors are trying to do it in a way that the state can afford and make some progress towards restoring a benefit. And that's why I believe this was brought forward. And the sponsor's here, he may want to.
Yes, please, if you want to step up to the microphone.
Exactly as said.
State your name, please. Just for the record.
I'm Kevin Pratt, Representative Kevin Pratt, retired fire chief, fighter 42 years. And also 5 years with Seabrook Nuclear Power Plant, Senior Fire Brigade Leader. So I have private service and I have municipal service, so I can see both sides of that. This is basically written to restore a benefit that was already there. We thought for many years that it was changed to the 3 highest years and changed to the 5 highest years. But with this one line at the end, it basically excludes the 5 highest years and really substantially changes and makes it unfair for people that work or get promoted in their last 5 highest years. It doesn't have to be the last years, but it's the highest 5 years. So it's not necessarily the last 5 years, but it could be. It most likely is if they get a promotion, it would be in the last 5 years. But it doesn't have to be. It's just the highest 5 years. So it's not fair for some employees to work and not get recognized for the money they put in for their retirement. It's like 11, almost 12% now. So they're paying like 12% on 5 years of work that they're not getting recognized for. So we wanted to straighten that out, and that puts it back more in line with the way it was for this group too. Group 1 may want to consider their own bill in that same idea, but the number of people that are in Group 2 compared to the number of people in Group 1 would be substantially different in price. There are more teachers in Manchester than there are in all the firefighters in the state of New Hampshire. So the numbers of people that would be included in this would be substantially increased if you did that. Any other questions?
I had a question, just writing things down. No, thank you.
Yep.
I forgot.
So we're just trying to clarify it,
Yep.
make it as simple as possible in one paragraph, as opposed to making it more complicated, and also make it fair for the people that are putting into the system. Basically, it's a fairness issue.
Thank you. Any questions from the committee?
And let me just touch on the recruitment and
Oh,
retention.
yes, please.
Yeah, that is very, very true. And it's very true not only in the full-time union fire departments and police departments, but it trickles down into the call and volunteer fire department ranks. Many people have started in the volunteer and call ranks and worked their way up to become a full-time person. And now it's not as desirable to do that with these massive changes that took place 10 years ago. So now you're seeing, and with the other things that are happening in the country, policemen and firemen jobs are not being flooded with people anymore. I was also 18 years fire stands and training commissioner, and we saw the numbers of people taking the test dwindle down from hundreds and hundreds, like 300 at one point, down to like 50 people. And the 50 people that pay to take the test don't even show up. Half of them don't even show up. So it's getting scary in the near future. And what's going to happen is when this here goes into effect, people that never understood this was going to happen, and I've been following the system very closely, and I didn't realize there was a 5-year exclusion on the highest 5 years. You're basically going to calculate your retirement on year 6, 7, 8, 9, and 10, which are very low compared to the last 5 years, or the highest 5 years. So what's going to happen is everybody's going to wake up, and they're in the system now, and the people looking to come into the system, and they're going to go, wow, I can make so much more money in the private industry. I took a $10,000 pay cut to come from the nuclear industry to the fire service as fire chief, and that was one of the highest paid positions you could get. And I took a $10,000 pay cut. When I retired, it was $20,000 more I could have made if I stayed there a year. So people are going to start to stay in the private sector. They're going to do all kinds of other jobs, and they may not even be in the fire service. So this is going to have long-term terrible effects for retention and recovery of people, and retention of people. And I could go on all day, but I won't.
Thank you. Any questions? So the fact that this was done, I think that was somewhat advertised by the retirement system. I saw some documentation from 2011 where this was described, but somehow many people don't pay attention to those. Is that the problem?
The retirement system does a very good job about sending people out. Anybody that wants to have somebody come to, and they did it in Rockingham County, they'd bring it out to their county buildings and different places to educate people. And it was said over and over again, instead of your top 3 years, it's going to be your top 5 years, is what they're going to base it on. And everybody said, well, that'll be a little bit worse because it's going to include 2 years that are lower. But that isn't what happened. It actually ended up being they excluded your 5 highest years, and that's not the way it was educated to people. And for many years, everybody did not know that there wasn't going to be your 5 highest years were going to be excluded totally. So you're paying into the system for 5 years that you get no credit for, and that's just plain not fair.
Okay, thank you.
Yep.
Oh, question?
Just a comment, if I may,
Please.
because we keep hearing we're restoring a benefit, but it's not fully restoring a benefit. If you look at the numbers from Art Beaudry's that he has in front of us, that prior to 2011, you'd be making the $25,000 upon retirement, and with this bill, you're making $21,000. So it's not fully restoring a benefit. So we need to just remember that we're partially restoring a benefit that was
That's a good
earned.
point. That's a good point. I kind of misspoke there. There was 7 things done 10 years ago that changed the system forever. This is only one of those 7 things. So you're only restoring one little piece of it. And this piece here is a fairness issue. If you look at the other 6 things, you could discuss whether it's fair or not, but this one here is definitely a fairness issue. You shouldn't be paying into a system that you don't get credit for. Yeah.
Okay, thank you. And to recall, I think this is coming out of the general fund, right? Yeah, okay. Oh. Would you like to speak? Oh, yes, please, yes. Thank you.
Good morning, Mr. Chair.
Morning.
members. Michael Gear, I'm the New Hampshire Police Association President. I just want to reiterate what everyone had mentioned, the retention and recruitment. It's a tough subject. It's not a secret. Every police department in the state is short on staff. And I think this bill will help in retaining people. 1. 2, this is a subject where everyone is talking about in the state of New Hampshire. Every law enforcement, firefighters, we're all talking about this subject. And I think restoring or put it back the way it was before, it's going to help every department in the long run.
Okay, thank you. Any questions? Representative Gawley?
And when you talk about that, wouldn't that also lead to, if you could, recruitment and retention, especially the retention portion of it, save municipalities money and not having to continually recruit and train individuals?
Correct, because it does cost a lot of money every time a police officer leaves the department. You'll have to replace that police officer, and there's a lot of money that you have to spend again, over and over again. It's costing municipalities a lot of money to get that person started and out on the road.
Thank you. Follow up?
As well as overtime for the unfilled positions?
Correct.
Got it. Thank you.
Thank you.
Question? Thank you. All right. What else do we- Any more discussion? Any ideas? Anything? Yes, please, Mr. Representative Gawley.
If there's no further discussion, I would make a motion, Mr. Chair.
Any discussion? All right. No discussion? All right. Oh, please.
Yeah, I'm not going to
Representative
support
Stelzner.
this. Just a couple of things. The idea that they're having problems with recruiting and retention because the retirement system doesn't count the last 5 years, I just don't think it follows, because recruiting and retention is a global problem right now. Nobody can keep anybody. Even in the private sector, they're throwing all sorts of benefits and bonuses at people, and people are moving on. I think it's a 20th century mentality that somebody stays and works for one place for a whole career. And I just think that we're moving away from that. And then I wasn't actually surprised when I learned about the retirement system that, it failed its contributors, being a government retirement system. But to dip into the general fund and rope in additional victims to the retirement system, that that will now be contributing to it but getting nothing back. I don't think that two wrongs make a right kind of thing, and these are the reasons I'm not going to support it.
Thank you. Representative Gawley?
Thank you, Mr. Chair. I do have to respond because recruitment and retention goes well before the situation we're in today. When this bill was passed and these changes took place in 2011, 2012, well before this economy is where it's at today and having an issue with businesses recruiting and retaining employees, the fire service, the police departments, corrections, all started seeing a dramatic change in recruitment and retention just due to the changes that were made in the system. So it shows, if you go back and you look at the municipalities, that it wasn't because of the economy we were in, it was because of the changes that we made. And when I go back and look at using general fund money, the state used to put in 35% of the cost to the municipalities and no longer contributes. So I think we had a precedence there setting that the state did pay for a portion of the retirement funding for municipalities, and this would just be a small amount versus what they had contributed in the years past.
Thank you. All right. Any, yeah. All right, yeah. If, I guess Representative Gawley, if no more discussion, please state your motion.
Move ought to pass on House Bill 1587. And I think I've said enough as to
Maybe a
what.
second?
I'll second.
Okay.
Second.
Yes, please speak to your motion.
And I think I've said enough reasons why we should be doing this. You know, let's just remember that we're not fully restoring a benefit when you look at the numbers, but we are at least adding those years in that the individuals are paying into the retirement system, having money taken out of their paychecks for a benefit they're not receiving during those years.
Thank you. Would you like to speak to the second?
So I support this bill because it does fix a problem. Well, at least it makes a problem not quite as bad as it is right now. I am concerned that planning and changes related to the retirement system that come before the legislature, we see them every year, and it's like just we're doing piecemeal patches, and I just think that it would be better to do some forward thinking and try to address all the issues more comprehensively. But since this puts a Band-Aid on it, I support this bill.
Thank you. If no more discussion, yes, please, Mr. Clerk.
Representative Santanastasso on OTP on 1587.
No.
The clerk votes no. Representative Gawley.
Yes.
Representative Fellows.
Yes.
And the chair.
Yes.
So that's 3-2. It passes.
Thank you. I think we're done with the subcommittee. Sorry, I dragged everybody out.
Does this go to, this goes to finance, right? Does it go anywhere else?
It needs to come back to the full committee first.
Well, yes.
But yes, it will. I think, yes, it should go to finance.
Now, just a little bookkeeping. These forms record the count, but not who. Do you want the who also? Who
Yeah,
said
yeah,
yes and
yeah,
no?
yes,
Yeah.
first and second, please,
But
yes.
it's no place for that on the form.
Oh, okay. So I think we're done, thank you. I was expecting a longer discussion, sorry, dragged everybody out so early. Thank you. this extra here. Oh, you got it?
You're only giving them a little bit of what they put into the system. No, there's no spiking. Who put that thing into the middle curve in finance? When they changed all these laws, Neil all of a sudden come up and said, well, we don't want to give them the highest 5 years. He said, but that's an average. You can't average a career and take out a chunk of it. Why don't you take out the first 5 years then? Take out the highest years. Exactly. That's so fun. And if you look at in my document, it's not, you're not spiking, you're getting $1,000 and you're putting in 25 grand. That's right. That's right. Thanks, buddy.
Yeah.
Thank you.
Well, very good.
I gotta thank this representative.
That's on our way. Thank you.
I will, mention that, Mike. Sir?
The buyback bill?
They have not, but it may be this is so far. So there's an amendment to take the amount in the system of the local communities would pay that 210 and have the state. So there's no impact on local communities. The state picks up 100%. So, and I think it's likely a 4-to-1 vote on that.
Yeah.
And I think the other 4 are vote to move it.
Another thing that, it would require a lifting different limits from the statute. If they wanted, legislature changed all our other service credits back in 14 to say it shall be the full actuarial cost calculated by the actuary. So if that language was in there, it wouldn't cost the state anything. It may cost an individual more or less than the flat rate based on, when they're gonna retire and the salary stuff.
So we thought about that too. Well, first of all, if they're willing to go with the state,
Yeah.
they got some, that would be like the last 50.
Yeah. The way it was, I'm wondering if, $100,000 is a lot of money, but
Well, yeah, we're the only state that does it. Yeah, hospital. Right, right. No, that makes sense. Well, she didn't tell me that. Well, I have. Okay. Yeah, but, adjacent chapter. So I'm getting rid of. Okay, yeah, let me, we'll talk about this one first. Oh, yeah, yeah. Okay, all right, sure. Yours may be just like that. It might be, yeah,
I had to find a few places where it's
right,
this chapter is
yeah. Because you don't want random parts of statute referring back to something you just eliminated.
just to be more clear.
Yeah, clean up, exactly. Yeah, like I said, I'll talk to her.
Yeah.
I don't even know if,
I think it is on the 4th for some reason.
I scheduled it for the 4th? Okay.
I was looking up the, give it to me, Chuck. Oh, no, maybe not, just for future discussion.
Turbo model.
Okay.
The other one I wouldn't punch for some reason, so.
Yeah,
I want everything.
yeah, me too.
Act Education, the chair's policy is that at least, for the people that normally, like the DLE people or anybody else who normally provide testimony, they won't accept it if they're not three-hole.
I've told our committee researcher, you do something, three-hole punch it, because everybody.
I asked them anything got printed, have a three-hole punch, because the machine will do it. He said, they don't want to do that.
Slows it down, but give me a break. If there's nobody up there, come on. It's seconds.
Oh, I know.
Took so much discussion. Is that the one that just gave me? I got so many copies of it. I've got it.
It's just not January.
If anybody's got a filled out pink card, they can bring it forward.
How you doing? Oh, you're here, okay.
Yes, your nameplate was upside down. Fixed it. How you doing?
Hey, thanks.
If you're trying to frame a situation. But, sometimes.
Good morning. I have a couple of announcements. First, there are in our office a supply of copies of the Retirement System Annual Report. I also have one set of all the CAFRs for the state, the Liquor Commission, and a couple of others. Anyone who's interested is more than welcome to borrow and read them. You might even keep them as far as I'm concerned. But they are available for your perusal. And a reminder, we will be execing on Monday. If you're not going to be here, you let me know. So you've got a okay, I'll get a replacement, no trouble. Okay. Anyone else, again, let me know. So, I'll open the hearing on House Bill 1357, and I don't see any of the sponsors. Representative Schmidt, since you're passing by, would you care to introduce this?
Morning, everyone. Madam Chair, thank you. I'm introducing House Bill 1357 relative to land acknowledgement, which I happen to be fully in support of. Let me just pull out the right sheet here. This is sponsored by Representative Cushing and has got a boatload of distinguished people supporting it. And I see a couple of my indigenous friends who are here this morning, and they will be happy to speak to this issue. But as I say, I think it's a good idea. So I'll take no questions. Thank you.
Thank you, Representative Schmidt. Mr. and Mrs. Poulat?
Ourselves first.
Kwai Niederbach, Indelawasin, Denise Pulio, Sagama Squaw, Widelawasin, Paul Pulio, Sagamo, Kawasak Band of Pennacook Abenaki people, Neona Ayan, Alton, New Hampshire. Yes,
And
ma'am.
it would be helpful if you were not in a mask.
I'm sorry, the indigenous population has a 20% survival rate at catching COVID. I'm okay with that. That's fine. You just have to let me know. I can adjust accordingly. Kwai Niederbach, Indelawasin, Denise Pulio, Sagama Squaw, Widelawasin, Paul Pulio, Sagamo, Kawasak Band of the Pennacook Abenaki people, Neona Ayan, Alton, New Hampshire. Hello, friends. My name is Denise Pulio, and this is Paul Pulio. We're the head speakers of the Kawasak Band of the Pennacook Abenaki people, located in Alton, New Hampshire. We're here today to speak on behalf of HB 1357, an act relative to a land acknowledgement here in New Hampshire.
One of the handouts we have given you was from the Native American Indian Commission. The commissioner herself is not feeling well, so she couldn't be in attendance today. So one of those handouts has to come right from the New Hampshire Ann Jennison, the chair of the Native American Commission. Our band has been working with communities, businesses, and organizations throughout New England that are acknowledging the prior history of land use by indigenous people by making statements of recognizing the land was once indigenous land and it's now being stewarded by other people, colonial people that have taken over our lands. Most notable are some of the bigger institutions like the Courier Art Museum, which has now put in their foyer a statement similar to this. Many of the churches within the New Hampshire area have already adopted similar land stewardship statements, recognizing that indigenous people cannot maintain this land as they once did and that they are now stewards of our land. This goes back historically to George Washington. Washington recognized that during all of the turmoil of Indian wars in New England and the Northeast, that the lands were pretty much taken from indigenous people. So when the Constitution and the Declaration of Independence were written, in 1790, George Washington signed off on a non-intercourse act, or intercourse act as it was written back then. It was one of the first acts done by our Congress that recognized that only Congress should be handling the affairs of dealing with land acquisition, sale, and bartering and trade with indigenous communities. if you read some of Washington's deep diaries and history, you'll find that he had a deep love and admiration for indigenous people, in particular the Abenaki, which we have copies of letters from Washington acknowledging our support of the colonial efforts in the 1776 time period. There was also another treaty that was in an act called the Jay Act, which was done in 1794, which impacted us in the Northeast because it established the right to cross the border to and from Canada for indigenous groups back in that time period. So what we're doing here is we're asking that you to put this historical footnote, and that's all it is really, that this land was once occupied by our ancestors, and in particular the Pennacook right here in New Hampshire, right here in Concord. And all this does is it adds like a historical footnote in the preamble, and it ties in with the boundaries and the metes and bounds that were established between all the states, the geopolitical and other influences. So all we're doing is asking for this to be added as a historical footnote in the appropriate place in our state documents. We did note one thing, and it's no fault of anybody, but we noted that spell checking of our language is very difficult. And the second page just explains the fact that a couple of the words were not, they were phonetically spelt out, but not in our language properly. So we give you the second page showing the two words that don't make sense. Because our language is very complicated, the flora represents terms of saying we have a great forest here, because we're a forest people and hunter-gatherers. And the fauna we're referring to are the wild animals of our state, which were so important to us as a people back in those days. So the use of the language was requested of us in several locations. The University of New Hampshire had worked very deeply with us to try to come up with a land acknowledgement, because they recognized that the University of New Hampshire was a land grant college. If there's any other questions, this is really not a very debatable thing. It's just a matter of whether it would be accepted as a statement. It's consistent with what a lot of the churches, museums, and other institutions and schools have been doing by bringing into their preambles that this was once indigenous land and it's now being stewarded by other people. And we are grateful to that, because we are but little and small percentage of our population is still remaining, but we still like to think of this homeland as ours, being protected and stewarded by the great state of New Hampshire. And any questions?
Thank you very much for your testimony. Are there questions from the committee? Okay, thank you very much.
Thank you. Gisulini.
Representative Horrigan.
Thank you very much, Madam Chair. So I'm Representative Timothy Horrigan from Stratford County District 6, which is the towns of Durham and Madbury. And so yes, as you already know, it honors the Pennacook, Abenaki, and Wabanaki people who still are who were and really still are the original stewards of the land variously known as Endikina and New Hampshire. And the peoples of our state, regardless of how long ago we came here or why, we're all dependent on the land, the flora and the fauna for, everything we need to survive, throughout the land and its resources. And I forgot to mention the water, but without the resources of our land, we're all totally helpless, much as we, and it's appropriate it's being heard the first day of Black History Month, since this bill shows the history it's not just the white people's history, that there's people of all colors here in New Hampshire. And it's also appropriate it's being heard, I guess I'm probably reasonably loud, but my mask is kind of scraping against the microphone, so I'll take the mask off for the brief period it takes me to speak, which hopefully will be about 1 more minute. So it's appropriate while we're dealing with a pandemic and political unrest, because the land now known as England was originally settled, or more accurately stolen, and some of my ancestors were part of that during a time of pandemic and unrest. So when the people we know in the history books as the Pilgrims arrived in what is now known as Massachusetts, they encountered a beautiful, well-tended, unpopulated land with fields and forests, which seemed to be perfect for their colony's needs. And they also found a number of mounds where corn and beans were conveniently buried, and they assumed that God had left them there, but that's not what happened. The land merely appeared to be unpopulated. The Abenaki people were decimated by a plague. It's probably smallpox, but we're not sure, and which also led to war and civil unrest. And those conveniently located mounds were graves, and they were left there not by God for the Pilgrims' benefit, but as a tribute to the dead who were buried in the mounds. So that's and actually they founded the town of Plymouth, Massachusetts, where Plymouth Rock was also an indigenous village named Patuxet. So it was and they celebrated their 400th anniversary, ironically, during the year of the pandemic in 1620. So this bill is very timely, and I think it's very appropriate. It goes in RSA 1:1 right at the beginning of the law book, since as I said, the land and its resources and the people are the basis of everything else that the law books deal with. All over 600 volumes of it now. So that's why that's why I support this bill, and I urge you to find it ought to pass. And also, just mention a little thing. It takes the existing RSA 1:1 about perambulating the boundaries, and it makes it 1-A, which is a simple change. I did notice we don't perambulate the boundaries with the province of Quebec, which I thought was interesting. But of course, it is part of a different country, so maybe that's why it is. So thanks.
Thank you, Representative Horrigan. Are there any questions from the committee? Seeing none, thank you.
All right, thank you.
Janet Perkins Houlard.
One of my constituents.
Hi, good morning. My name is Janet Perkins Howland, and I reside in Durham, New Hampshire. I'm a member of the Indigenous New Hampshire Collaborative and the Human Rights Commission in Durham, which has recently adopted the land acknowledgement based on the one that has been adopted at UNH. I am in favor of this bill as I think it would be valuable as more than just symbolic. I have been incredibly fortunate and had the advantage of living in Durham for the past 24 years and have, it's no more evident to me over the past 2 years with the pandemic how valuable the land is. My husband and I have enjoyed countless walks on the Sweet Trail in Durham and have benefited from the land and noticing what the beavers out there have been busy doing, and it's just an incredible advantage. So in terms of how history is involved here, we all are aware that we're not individually responsible for past transgressions, but in the interest of reconciliation and restorative justice, we are responsible going forward. And I think I know that the lessons we learn from our Indigenous neighbors in terms of stewardship and protection of the land is incredibly valuable. There's so much we can learn. There's so many opportunities, and I think it starts with the land acknowledgement. Thanks so much.
Thank you for your testimony. Will you take questions?
Sure, if there are any.
Representative Lekes.
Thank you, and thank you for taking the question. You said that this is not just symbolic, so I'm wondering what you see as the practical effects of this beyond symbolism.
Mm-hmm. I think it speaks to the acknowledgement itself. So sometimes just opening people's eyes to the fact that there is land, and we're acknowledging that there is an Indigenous history, and that the land is more valuable to all of us if we steward it going forward. And as I said, I think of this as a very positive thing and not as a punitive thing at all. We all know how important the land is, even for our economy and for our enjoyment. So I think it's a mutually beneficial.
Okay, thank you.
Representative Pearson?
Thank you, Madam Chair. Thank you for taking my question. You use the word restorative justice. What does that look like? What's the end game here for what that means to you?
I would not feel comfortable speaking about the end game because I feel like that is that's a personal issue for some people. But as I spoke before, I think that the acknowledgement itself, it starts with the acknowledgement, and we're simply acknowledging that we are on Indigenous lands, and it brings up the opportunity to learn about how we, going forward, can protect and steward the land. So again, it's not, it's restoring things. It's not, it is not about punishment, it's about repair.
Are there any other questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Is there anyone else who wishes to testify on House Bill 1357? Yes, please come up, introduce yourself, and fill out a pink card.
Hello. Excuse me. My name is Owen Emberley. I live on unceded Abenaki Pennacook land here in Concord, New Hampshire. I like what this gentleman from the Kawasuk band said, that this isn't really a debatable issue. It seems like perhaps in this room there is perhaps some pushback about this, but I would like to represent people of my age, people of my generation, who many cannot be here today because most of us are working right now. But among my generation, this isn't really a debatable issue. It's very well understood that white Americans were not the first people to inhabit this land. I think it's also fairly evident that white Americans have done some things with the land that have jeopardized our economy, our climate, our nation. I think that there's much wisdom to be learned from the past. I believe that there's more that could be done, but I think that this is a step in the right direction. I view this bill as a litmus test for us right now to say, how do we feel about the past? How do we feel about what's happened? We can't go back in time and change what's happened. Can we do anything in the present that starts to correct some of those wrongs? And I think we can. I think this bill would be a terrific step in that right direction. I also think that, again, speaking from my generation, these are changes that are going to happen and are going to come. The question is when. As representatives all, now right now you all have the opportunity to be the representative body that did this for New Hampshire, which would be a great milestone, and I would really appreciate if this bill passed. Thank you. I'll take any questions.
Thank you. Are there any questions? Representative Lecca.
Thank you, and thank you for taking the question. You stated that, you think this would be a good first step. The question is, what future steps do you think it might lead to?
As the woman who just spoke before me said as well, it's a bit of a loaded question, and I'm not in a position to make any future steps personally, and I can see why there would be some fear for that, but I don't think there needs to be. I think if the way that our government is moving is being more open and accepting and understanding of our past and understanding of all the citizens that live here, I don't view that as a scary road that we're moving down. I view that as a potential benefit to our country and to our state. So I don't know what the end game is, but I do know that what has happened in the past here in this state has been morally wrong, repugnant, terrible. We can't go back and change it, but what can we do now? I think this is really a question of morality. That's why I called it a litmus test. Within your own hearts, do you think it's right that this land was stolen from another group of people? Do you think it's right that there was genocide? Do you think it's right that, as the representative here said, when the Pilgrims landed here, they raided burial mounds to steal food? I mean, do we think that's right? No, I don't think anyone would think that is right. So I don't have all the answers. This is a sticky, thorny question. I think it's great that we can debate it here openly. I don't know exactly what it would lead to, but I do think the opposite side of the question is, what happens if this doesn't pass? What happens if you vote no? If you vote no, you're standing for everything that has happened before. That's not a position I would want to be in.
Representative Baroda.
Although I agree with this bill, I'm concerned about your presentation because I view this bill quite differently from you, and I support it. Would you say that the one way of viewing this bill, and I think it might be the less confrontational way, is to say that history includes all people who lived on this land? There's no judgment on what was done because we don't know that. There's no to judge is not helpful, and it is not a looking for the right word. It's just not useful. So would you say that the meaning, the intent behind the bill as is written is to acknowledge that the Native American people who lived in New Hampshire are part of the history of New Hampshire, and that bill acknowledges that? Is that fair to say?
Yes, and I do understand that not everyone has to share my views fully on the subject for this to pass. And I was a little concerned about, am I going to overstep my bounds and come in here and say this and do something that would be detrimental to the bill, which I do not want to happen. But I still think it's a very important bill to pass. And it is what it is. It's an acknowledgement. It doesn't have any immediate effect on the governance of the state. I think it's the right thing to do.
Thank you for your testimony. Thank you, Representative Groda.
Thank you.
Is there anyone, do fill out a pink card, sir, so we can record your name. Is there anyone else who wishes to testify on House Bill 1357? Representative Schuett?
If the gentleman would take one more question. Thank you for taking my question. Would you agree that this bill could be a first step at current and younger generations learning about ways to protect the earth and help it heal from some of the things that previous generations have done to denigrate the land itself?
Absolutely, I do. And when I speak of past generations, it wasn't meant to be with judgment. It was meant to be as just an assessment of what happened. And I don't think we need to be afraid of the past. I think that if we understand the past, we can move forward in a better way. And I think that this very firmly roots us in the past and in the heritage of this great land that we live on. So I think it is very positive. And I do apologize if I went a little too far. Like I said, this isn't my bill. I'm not the one who wrote it. So I shouldn't be the one to answer for, what could this possibly lead to. I think it is written as just an acknowledgement, a simple acknowledgement of the facts of the people who came here before us. And I think it's very positive for our state. I think it would be a wonderful thing. I think it's a thing that if this was in New Hampshire's laws to start it off, it would be a benchmark for other states to follow. I love New Hampshire. I'm a lifelong New Hampshire resident. I think New Hampshire is a great state, and I would like to think more people think it's a great state as well, and I think this would be a good step for that. Thank you.
Any other questions from the committee? All right, still seeing none. Thank you for your testimony. And I'll close the public hearing. And I want to mention that out of respect, I'm not going to consider it an exec to pass this unless someone does an amendment to fix the spelling. Representative Schmidt or Groda, do you wish to do so?
I'll be glad to do that. Thank you, Madam
Okay,
Chair.
thank you. I think it needs to be done before we discuss it. Okay, we have a few minutes before the next bill, so we'll collect our card.
from a lawyer's point of view. I'm gonna do the lawyer's point of view. I've only been doing this for a few years, so, I've heard. I think we should mandate that everyone gets at least 8 hours of sleep. And if you don't, you have to pay a fine. It'll help the,
So I think the one thing with sleep is people are stressed out trying to go to sleep. They can't go to sleep.
You think of all the CPAP machines you can sell. Right. Melatonin sales will shoot up, right? You know. Sleep awareness month, okay? Probably not a bad idea. Otherwise, every day of the month we'll do something special. Right. Declaration or something, probably.
And that's really going to keep it alive. If you go out and take the list, but everybody feels to be like our boss, you know?
They're gonna have their own day.
Things that's what's consistent. So, yes, the impact vote against victims of communism.
Consistency is the hobgoblin of little minds, right? There we go.
All right, it being 10:30, I'm going to open the hearing on House Bill 1344, and I call Representative Silber to speak.
Thank you, Madam Chair and members of the committee. I had hoped that Representative Bernardi, who is the prime sponsor, be here, but since he's not and I'm a co-sponsor, I will introduce the bill. My name is Norman Silber. I live in Guilford. I'm a state rep from Belknap District 2, the towns of Guilford and Meredith. That being said, prior to this day, I'm a member in good standing of the New Hampshire Bar and have been a member of the New Hampshire Bar since 2008. And I've been a member of the Florida Bar since 1970. Scary thought. Over the course of my career, I spent a great deal of time on real estate transactions, and I've handled hundreds of real estate transactions, purchases and sales. This bill, everyone tells you that their bill is simple. This bill is truly simple. It only takes a few lines on the back page. One of the things that has always concerned me is, okay, first of all, even though I'm a lawyer, and I know a lot of people don't like lawyers, and I share that view from experience, real estate agents and real estate brokers and salespeople particularly don't like lawyers because they usually view lawyers as deal killers, not deal makers, deal breakers, not deal makers. I've always been, I thought, a deal maker. One of the things that's always concerned me is when a client comes to me and says, after the fact, they've signed this piece of paper, this is printed form that was presented to them in a transaction, and they were told, don't worry, it's just a standard form. That is, the alarm bells go off. I have never treated a printed form, and you can take a piece of paper. Nowadays, it's easy to make a printed form out of anything. In the old days, it was a little harder. But printed forms, I've always taken the view that I still want to read it, and I have no problem with taking, in those days, a ruler and a pen and crossing through lines and marking them up and putting an addendum on and making changes. Everything in a real estate transaction is negotiable. Notwithstanding the fact the real estate agent will say, in this listing agreement to list your property for sale, there's no changes accepted by the multiple listing service. You have to sign it as is, and it's just a standard form. That's a lot of nonsense. You can make changes on the thing, and the multiple listing services are happy to put your property in there. The problem that this addresses is that not all listing agreements, which is basically your contract with a real estate broker, says that here's what I want to sell my property for, this price or better. These are the basic terms. Will I finance part of the purchase price or not? Sometimes, not every listing agreement, but some listing agreements have a provision buried in the standard form that says that the broker is authorized to sign a sale contract that meets the terms of the listing agreement. Well, so by the time a person comes to the lawyer, they've already signed this form, and they say, the broker has already signed my sale contract, and there's portions of the contract I don't like. Well, at that point, it's basically too late. You're up the creek without a paddle. You really don't have much choice because you've already granted the right to sign that contract to the real estate broker. What this basically says, what the bill says, is that only the owner can sign the contract of sale or can use a power of attorney, a formal power of attorney that grants to their agent, called an attorney in fact, the express right to sign the contract of real estate. So most people who dislike lawyers, meaning all of us, do not seek out lawyers every day for everything they do. Usually you may get a lawyer involved in the purchase or sale of real estate, maybe a divorce, maybe an estate plan. But most people, if they're smart, stay away from lawyers. Highly recommended. The problem here is principally dealing with the average person doesn't know what they're signing, even though the law says that it's presumed that you know what you are signing. And so somewhere buried in this standard form, there may be this language, which sometimes it works out and sometimes it doesn't. And while if it doesn't work out and it produces lawsuits and stuff like that, I guess that's good for lawyers, but it's not good for the people, the average person who wants to sell their property. It's really pretty simple. You hire a broker, they bring you offers, you review the offers. If you like the offer, you sign the contract. Very simple. Why should you give up your rights to review the offers and give it to some other person whose principal interest is in closing the transaction and collecting a commission? That's their interest. Your interest is in selling your property for whatever terms you have set. So, and keep in mind that real estate brokers in our state, as in most states, can be in acting in a variety of capacities. They can be in a fiduciary capacity, they can be a transaction broker. There's a variety of approaches. So what I'm telling you, this is sort of a peek behind the curtain, as it were, from a lawyer's perspective, as having handled many, many, many real estate purchases and sales over the years. I think this is a good consumer protection bill. It is really, truly nonpartisan. It will protect the little people, particularly the elderly of our state, and those who don't run out and get a lawyer every time they're thinking about doing something. A lot of real estate transactions in our state are handled without a lawyer. The broker brings the contract, the contract gets signed, it's closed with a title agent. Lawyers may not be involved. You know, There's different views as to whether that's a sound way to approach the transactions. But if you're just, dealing with a small home or something like that, there's probably little harm involved. But the elderly can not know what they're signing, but they sign something that legally binds them. All we're trying to do is to say, you need to know exactly what you're agreeing to, or give a power of attorney with an express grant of the right to sign the contract. I'll be happy to take any questions.
Thank you, Representative Silber. Are there questions from the committee? Representative Schuett.
Thank you, Madam Chair. Representative Silber, I see in the language several places it mentions power of attorney, but I also see on behalf of an owner by an attorney in fact. What does that mean?
A power of attorney is a formal document where an individual, which is called the principal, designates an agent to act for them, and that agent is legally called their attorney in fact. It's just legal gobbledygook.
It's
Thank
just
you. I was
specific
familiar
language
with
of the
power of
profession.
attorney, but I had not seen an attorney in fact before. Thank you.
Yeah, it's legal gobbledygook. It's so that you have to go hire a lawyer to explain it to you.
Thank you, Representative Silber, for providing us free legal service. I hope that's not a violation of your bar agreement.
I don't think I'm on the favored list of the bar these days.
All right, other questions? Representative Sitek. Representative Fellows was first.
Thank you. This is just kind of a follow-up to that last question. So for the power of attorney, does that need to be witnessed by a
Notary.
Yeah, and does the same? And what about the contract? Does that happen?
A contract of sale does not need to be witnessed or notarized. A listing agreement does not need to be witnessed or notarized. A listing agreement where you hire the broker. There's some RSAs that deal with a power of attorney and what the requirements for a power of attorney are in New Hampshire. I would be remiss to try to tell you that I am fully familiar with that. So, but basically, a power of attorney typically is a formalistic document that has state your name, hereby appoint the person, the power as my attorney, in fact, to do the following things, and no others. You can have a general power of attorney to do everything on my behalf. You can have a specific power of attorney. And what happens is the power of attorney, if you pass away and you've issued a power of attorney, the power of attorneys disappear. They are null and void when you die. Now, New Hampshire, I do know that the New Hampshire law on powers of attorney makes all powers of attorney durable, which means that even though you are incapacitated legally, which in many states would mean that your powers of attorney are null and void, a durable power continues even after legal incapacity. So unless your power of attorney in New Hampshire says that it's not durable, it's presumed to be durable. Too much information, probably.
Yes, thank you, Representative Silber.
Yes, I simply wanted to know in terms of the notary. Does a notary, do you have to have it notarized to have a power of attorney?
Representative Fellows, Representative Silber said he's not familiar with the laws of the state, but he did reference them, so.
I'm not sure.
You don't know? Okay, thank you.
Questions? Okay, seeing none, thank you very much.
Thank you very much for your attention.
I call,
obviously, I want this to pass.
I call Jenna and Archibald.
Thank you, Representative McGuire, and thank you, committee members, for hearing my testimony. My name is Janan Archibald. I'm here representing myself.
You need to be closer to the microphone, please.
Okay. From 2008 to 2020, I owned a small business specializing in personal property appraisals and senior downsizing. I was also a licensed New Hampshire real estate agent for part of that time. My job afforded me the opportunity to work with senior clientele as they move from their large homes into continuing care retirement centers and independent living facilities. During my tenure as a downsizing professional, I became very involved in my clients' lives and bore witness to situations involving elder exploitation and abuse. One may think of physical abuse when hearing the term elder abuse, but the U.S. Justice Department defines elder abuse as caregiver negligence, financial exploitations, physical abuse, and psychological abuse. The National Adult Protective Services Organization, herein referred to as NAPSA, breaks down elder financial exploitation to 9 categories. One of those categories pertains to real estate. And the definition states real estate involving unauthorized sales, transfers, or changes to property titles may include unauthorized or invalid changes to estate documents. NAPSA also lists abuse of power of attorney as a form of financial abuse. The aftermath of elder abuse or exploitation doesn't end after an incident. Reports and studies have shown that seniors lose $2.6 billion a year due to financial abuse. Elderly victims of financial abuse are 3 times more likely to die and 4 times more likely to enter a nursing home. And almost 1 in 10 financial abuse victims will turn to Medicaid as a direct result of their monies being stolen from them. For the first time in history, the Census Bureau projects the population over the age of 65 by 2023 will be the largest demographic in the United States, well outnumbering children. 1 in every 5 U.S. residents will be at retirement age. To those of us who take the time to advocate for senior rights, this is a scary and daunting statistic. While the system of elder care may be structured with the best of intentions, getting care and transparency in many areas requires a high level of advocacy to get the services and treatment as required by law. I don't see the need for advocates going away by 2030 or beyond. If anything, there's going to be an increased need to help the aging population, and I'm fearful there won't be enough of us advocate types to go around. In lieu of advocates, a big stride we can make as stewards of humanity is establishing sound legislation that promotes honesty, integrity, and transparency. This is why I'm in support of HB 1344. Simply put, this bill does not allow anyone to sign a purchase and sale contract on behalf of another person without a power of attorney on file. As a realtor, this would seem obvious to me. A licensed realtor is bound to a strict code of ethics, and in this code of ethics, it defines standards of practice that address contracts and the role of the realtor. This legislation would be a nice accompaniment to Standard of Practice 9.2, which states realtors shall make reasonable efforts to explain the nature and disclose the specific terms of contractual relationships being established prior to it being agreed to by a contracting party. Perhaps even more applicable is the protection this bill would provide against unauthorized third parties signing documents on behalf of the seller, such as guardians, relatives, and/or friends or household help, since over 2/3 of elder abuse is initiated by spouses or family members. As a former senior move manager who has moved hundreds of clients in New Hampshire, I can say the most valuable asset the vast majority of my clients owned was their homes. Most needed this money for retirement and down payments to move into CCRCs or independent living facilities. For most, this was the last real estate transaction they would ever enter into, and the proceeds of the sale were vital for maintaining their financial independence. The process of signing a purchase and sale agreement is easier than it's ever been. The documents are available online in electronic format, such as DocuSign and .loop. Theoretically, a legally binding document can be signed in a couple of minutes sitting in front of a computer. While I cannot speak to the legality and available recourse to individuals who are victims of a fraudulent contract signing, I can say that I have witnessed the anguish and frustration that clients have had to endure in the aftermath of such an incident. Resolving conflicts like these can take months and years to go through the court system. Generally, time is not viewed as a commodity that can be thrown around within this population, and the will to fight injustices is just not as intense. That's why I ask you committee members to take this small step towards ensuring we have sound legislation on the books that protects the interests of our seniors and vulnerable population in the state of New Hampshire. Please vote in support and not to pass on HB 1344.
Thank you for your testimony. Are there any questions? Representative Schmidt.
Thank you, Madam Chair. You're obviously reading from a prepared document. Can you provide that to the committee?
Yes, I did email it to all the committee members.
Thank you.
Other questions? Seeing none, thank you for your testimony.
Thank you for your time.
Chris Norwood.
morning, Madam Chair, members of the committee. Thank you for the opportunity to speak. For the record, my name is Chris Norwood. I am the 2022 Public Policy Chair with the New Hampshire Association of Realtors. We are in support of the bill, and I wasn't planning on testifying, but there were a couple items I just wanted to clarify and just mention to our support. I think for all the reasons the past speakers meant, that this is a prudent action not to have realtors have power of attorney. I can say in my 20 or so years of career, I've never been granted a power of attorney by my clients to also enter into a purchase and sales agreement on their behalf. I just think it's a prudent thing to keep a separation of church and state, so to speak. But a couple points for clarity. First, in a past life, about 5 years ago, I worked on the forms committee for the Commercial Board of Realtors, and I can state that there is no standard in those forms that speaks to a power of attorney. And I'm not saying that it has not happened, but what I am saying is that it would take an act upon a licensee to affirmatively put that language into the additional provisions section of a listing agreement. And again, not disputing that that might have happened, but I just want to make the committee aware that there is no standard language in the realtor forms that grants a POA or an attorney in fact to a licensee. The second piece, while I wasn't planning on testifying, I did prepare because I had the same questions as some of the committee members did relative to a power of attorney needing to be notarized. Thank you. So I'll just read briefly from RSA 564-E:105(2) letter B. A power of attorney to convey real estate must be signed, open parens, other than by electronic signature, closed parens, by the principal or in the principal's conscious presence by another individual directed by the principal to sign the principal's name on the general power of attorney and must be acknowledged before a notary public or other individual authorized by law to take acknowledgement. So again, in the realtor's viewpoint, unless that listing agreement had a notarization, the power of attorney that would have been granted in that listing agreement wouldn't have passed muster. Again, supporting the bill, we just wanted to clarify those points, and I'm happy to entertain any questions of the committee. Thank you.
Thank you for your testimony. Are there questions of the committee? Representative Syed.
Mr. Norwood, if this is not a standard check on a real estate form, that it actually has to be inscribed, added as a codicil or whatever, and notarized, is this bill necessary?
The second half of the bill would confirm that you couldn't do it in one single document, Representative. So any contract, let me just read this one. Any contract. I guess what I would say to this representative is the bill, what the bill would codify is that there would have to be two separate documents. And so while, yes, someone would have to insert that into the listing agreement, and to your question, we would have to include a notarization to our listing agreement, which doesn't presently exist. This bill would signify to say, hey, you just can't do that all in one piece of paper. It's got to be a separate piece of paper that would clearly draw attention to the fact that you are granting a POA to a licensee. I think that would be the intent of, or not the intent of the bill. I think that that would be the practice of law if the bill were to be passed.
Representative O'Brien.
Thank you, Madam Chair, and thank you for taking my question. If this bill passes, the previous speaker mentioned a standard of practice, I guess, the realtors perform. Upon passage of this bill, would it be adopted into that standard of practice for realtors so they would know about it?
So thank you, Representative, for the question. I can say those Those standards of practice are part of the National Association of Realtors, for which we get training on every 3 years. But the adoption of those standards of practices take place at a national level. So the realtors within the state of New Hampshire don't necessarily have the right to amend that. And this may not be what you're asking, but I think that there may be examples whereby realtors would still have the separate power of attorney, because that's clearly what their clients wished, if that makes sense for all parties involved.
Follow up, if I may. 400 representatives, plethora of bills. How would the realtors know what we're doing here and what our intentions are in this bill? Will it filter down to the realtor?
Thank you, Representative. So as far as the training goes, I can tell you that I've had numerous conversations as Chair of Public Policy with the educators in our state who train on the 40 hours of pre-qualification, as well as the ongoing qualifications, 15 hours every 2 years. The educators have been very much involved in the Public Policy Committee, and they would be aware of the bill.
Thank you.
Are there other questions? Yes, Representative Allegro.
Thank you, Madam Chair. Representative O'Brien brings up a good point about this information filtering down to the people practicing this. But am I correct in, I don't think you need to be an attorney to see this, but am I correct in assuming that regardless of whether or not it filters down, if this law goes into effect, it would protect clients, essentially nullifying any accidental or nefarious application of these kinds of power of attorney, hidden powers of attorney? I mean, that's what the law is going to say.
Thank you, Representative, for the question. And as I stated prior, my personal belief, though not a lawyer, would be that that power of attorney that was otherwise put into a listing agreement wouldn't be in effect because it was not notarized. But I do feel it's as an attorney friend once said to me, it's a belt and suspenders type approach, right? So it's kind of covering both bases.
Representative Schuett.
Thank you, Madam Chair. I thank you for the cite of the other RSA regarding power of attorney. And I don't know if you know the answer to this, but it sounds as though that power of attorney, if it's notarized, could be granted to someone other than a practicing attorney. Is that correct?
Yes, Representative, thank you for the question. I have worked with parties who have had power of attorney who are not attorneys, who are relatives and so forth, or just otherwise a trusted individual to the seller.
Thank you.
Any other questions? Okay, seeing none, thank you for your testimony.
Thank you, Madam Chair.
Is there anyone else who wishes to testify on House Bill 1344? Okay, seeing none, I'm going to close the public hearing.
Back up 1 second.
Yep, so.
Say that one more time? Your what?
My wife passed away Saturday.
Why do you say that?
Because that was our business.
Okay.
So we shut it down. We shut it down on the third. I don't want to listen anyways. You know what, I have another bill for 2 hours next week, Mike.
Way overshot.
Way overshot. I said, I'll come and listen to the real estate
did. Holy cow.
Keep your mind sharp. You could have come and listened to the Burgess bill. They got that.
Burgess.
Well, we're kind of in between.
So they
just hired a new legal counsel.
That was today?
Yeah,
Said it?
that was, yeah, 9 o'clock, 9:30 at Senate Energy.
And on that,
Senate Bill 270.
I don't know what they, I'm just not in favor of extending any more things to them,
Yeah.
especially the way they run the business.
Well, what they're trying to do is basically.
Tina's the program specialist. Been there for a while. She's still there. Yeah, I mean, she'll report into.
Right, I kind of went over that a little bit reading the other day, so.
Oh my gosh.
No.
We got 52
Yeah, so,
sets of administrative rules. Schmidt, how are you? Good to see you. Shane's doing a good job. Yeah. Good.
Obviously, he's one.
Rick Lee, and she's transitioned into that senior role really well.
Give him 3 years. It's my opinion. I don't know how you feel. That's how I feel. I mean, I understand the wood industry part of it. It's like, I just can't do it again. It's like,
Yes, I mean, I don't have a much.
these people, I do have a couple investors in the business.
Right, exactly. So I don't think it's.
Yeah,
We're just gonna say, we get
the
lots
problem
of
is,
calls.
that thing was overinflated when it was built.
It just closes those two
$100,000
loopholes.
makes sense to construction.
Oh, for sure.
So I don't know where they're at, 'cause I know she's looking at the ties to buy it.
Exactly. So that's what I'm gonna say. You know,
So
we
we're gonna do
a lot
that
of
commission,
service issues that
you
closes
know,
a
low
couple
grade
loopholes.
timber, I don't know if you're looking at that.
Happy to answer any questions.
And I will be reporting to you on that.
Okay.
So tomorrow the resources will present.
Sure.
It's gonna be definitely. I will, I gotta, I have a meeting in the morning, so what time is it?
I like that, yeah.
1:05:10. I got a meeting at 9 with the chairman of the board. For executive 15 days. That's one thing. No, there's 15 bills there. I was out of work. My wife recognized me. But she used to say, I was overwhelmed, I didn't sleep. I'm tired still. Built up to people. You have a home and stuff. But you know what, I had no choice. I had to bring them to hospital. People see them. They won't recognize it. They're interpreting the word resident, not a resident, someone who does stuff. She went to Dartmouth, but they did oncology right away. They have Dartmouth does, Dartmouth, her doctor was out of Dartmouth, comes up 2 days a week, get weeks. And we went down for like any other stuff down to Dartmouth. Yeah, it just came really quick. We went on a couple of trips. She had been doing pretty good, and all of a sudden she's bang. It's turned to a switch. Oh my God. Yeah,
Of course you
yeah,
remember the
sick.
issue, but there.
And then she lost like 22 pounds in 2 weeks. So we put her on hospice. So it told me about 4 weeks. She died right in 4 weeks. But I brought her home. Well, she was home. I brought her to the doctor's on the 27th. After Christmas. Came in the morning. I was pretty upset. So I said to hospice. I brought her home. And she lasted 4 weeks.
Have you emailed us?
First 2 weeks.
No, I didn't have anything in writing.
I had come down here.
This helps me is.
Past week before I came down. But I had people who were
Like the other.
one of the reps represented Davis, over my his daughter that's, so she stayed up in writing.
Of course, this is still a moment.
Yeah, she got there early, so I could come down.
As long as it's this, the national.
I'm paying my daughter for 12 years. She's been doing it for like 12 years. How things going in the wood industry?
We don't know legal or illegal, but this cold weather's very.
Well, I've been thinking that even Burgess
depending on, or if they're the moms and the trustee assigned, that type of thing happens a lot. I think that's the major issue.
So how's
this
Grant
bill
helping
clearly doesn't address that. But that would be a concern of ours.
Very good. All right, say hi to Mom for me. Love you. Bye-bye.
Not clear. Maybe.
Needs a little polish.
Yeah, I mean, they're drafted by people.
The governor comes up and he says to me, the governor tells me I'm quoting reading from 577. He says, this is about growth, not about.
I think that second one.
Growth, because they wrote back over the payments from taxes back in, so like a couple of years ago, they got a check for $5,000. And the governor told us to go ahead with this bill. And then, the governor was up there last week, ready to bash the shit out of it. Like, oh, say to myself, you're not doing yourself any favors. You know, he's. Okay, good, yeah, so we're ready to go. Just the governor, so the governor, I wish the governor, the governor. I try to work with all the candidates. But each time working for Sanssouci, Jim Wheeler. Yeah, so we're doing, I've been in the office with it, because our office is when you first walk in the building. Jim walks by me one morning and says, hey, Jim, he goes, oh, by the way, Troy, I'm starting here today. That was like on December 2nd or whatever, he stopped in one day. He's working full time, but Sanssouci. Must be doing very real, yes, that's, they do it all over the east and everywhere. He does a lot of public utilities and stuff. It's a big operation, but it's funny to see Wheeler in there. I said, the great news. I said, why don't you just pay this guy? Actually, no matter what, how well it's doing, Jim is really smart. He's good at looking at stuff. Yeah, Skip, the owner said, I didn't even ask him. He said, he just showed up. Wanted out of Pearl. I guess it was a couple of, Like at Lancaster, it's like, yeah, that's the first year, pretty good. I get the public budget here on Thursday nights. Yeah. The selectmen are the first year. Most part. Well, who are you fellows? It's Shane and I. Shane and I. His father. Mike. Yeah, Mike. So Shane and I, Shane got elected here with me, and then Rido's been here, he's been there for quite a while. Yeah. So he's up for re-election. Coming up, I think they're just kidding. And, well, Sampson was the town manager for 13, 14 years. Ed retired. And Ben Olson is now the best friend. He's the town manager. So I signed up to run. I knew they hadn't officially done anything. He calls me up last January and says, signed up. He goes, hey, you signed up for running for the selectmen. I want to be your boss. He started laughing. We get along really well. We've got great department heads in Lancaster. It's a great job. I get along with all of them. The girl that was doing all the work, legal work, Robin Irving.
Okay, quick. I'd like to hear your T number for first town. But the middle school, they have an ASU now, right?
And of course, she's a great writer, she's an attorney, she can do everything.
Right, okay, which is August 25th, 2001.
I'm still, she's still gonna help.
Today I'd like to code out
Again, she just couldn't.
Okay, right, very good. Yeah, I'm looking at the calendar, I'm driving. 3 o'clock.
Like Christine, Santa's Village. Yeah, so Christine's a good friend.
Yeah, so no problem.
Her sister is a
Very
bachelor.
good. All right, I'll see you then.
The other older sister went out to the Midwest.
All righty, thanks.
She was like 9 foot. So when Alice passed away a couple of years ago, that was almost 3 years ago, she had a car in Florida that trucked up. Listen, that was long, right? Yeah. 2013 Chrysler 200.
Okay. It having reached 10:15, I'm good. Oh, excuse me. It's 11:15, and I'm failing my clock reading.
The little hand is on the.
So I'm opening the hearing on House Bill 1354 and calling the sponsor Representative Acton.
Thank you, Madam Chair, and thank you all for your time. HB 1354 was a bill that passed before COVID and then, like so many others, just disappeared into the mess that existed back then. But basically, this is a change to the rules that allows licensed real estate agents who then go inactive to continue to collect annualized or periodic payments. So to give an example, several years ago, I was a active real estate agent. If I was involved in selling commercial leases or renting apartments or so forth, a lot of times the compensation structure is set up that you get paid per lease, and you will receive more payment if that lease renews in the next year. So there's deferred compensation packages. But the problem is that if I go inactive and am no longer actively in the career of real estate agent, being an agent, I'm no longer able to collect those annualized payments. So you have to forfeit the payments of your payment structure because of the rules in the real estate licensure. So this is basically, we're bringing it back up and to run it back through here. And I have two people that are going to be testifying, at least two. Ann Flanagan is a well-known person in the industry, does a lot of training and so forth. And then we have a representative from the OPLC to answer any questions. But like I said, we're here to try it again, and it's really not controversial, and it'll help the income of people like myself who get into the industry, and then for whatever reason you don't carry it on, you get your payments that you expect into the future. That's all I have to say today.
Thank you. Representative Broder has a question. Can you answer it?
Absolutely.
So I can understand that if you are an agent and you are actively working to get a lease fulfilled, but if you retire and you let your license expire and you no longer are able to do that, how does that pertain to you getting paid for something?
Well, if the contract that you're working on for payment suggests that you, or stipulates that you get paid each time that lease is renewed, then that's a payment structure, a legal payment structure that can be made contractually. And it would make sense if you, and this is common practice, that if someone you find to lease a building or an apartment renews that lease, then there's a number of compensation structures that allow you to collect each time that lease is renewed. But you can't do that if you happen to go inactive.
Follow up? So I can understand how if the same person renews the lease, that would be the case. But let's say that the lease, okay, so the lease is always between an individual, the same individual. What you're saying is if you were the real estate agent that established that initial relationship with that individual and the owner of the property, and that lease was renewed then you're asking for payment for that. But if there was that's right, because any other arrangement between two different individuals would not be a renewal, correct?
Yeah, if there's any change to who is leasing or something like that, but these are structured payments that are agreed contractually up front, and that we would like to be able to enable. This has been described to me as housekeeping, and we'll hear from OPLC and see what they think about it.
Thank you, okay.
Representative Acton, I want to warn you about using the word housekeeping. It usually means we're opening a can of worms.
Okay, thank you. I'm still
anyway,
fairly new, and that's the first one for me.
No problem. Representative Sytek has a...
You said that your deferred payment plan ends if you become dormant, retire, right?
Your ability to receive payment is only allowed currently if you are an active licensee.
Yes, if I may follow up. You're talking, is this an operation of law or an operation of contract?
Well, it's an operation of contract based on the rules that are stipulated in the OPLC real estate licensing. And I'm sure there's people who know more about this than me ready to testify.
Where I am going is if this is a matter of contract, you shouldn't sign a contract like that. You should get a contract that says your payments persist. You didn't die. I mean,
Well, sometimes, you know, people's lives change and they can no longer practice real estate and they wind up going inactive. So you can keep your license active, you're just not actively practicing. And we would like to see that as long as you're in inactive status, that you can collect on the payments that you're contracted to get.
Representative Rhodes?
Thank you, Madam Chairman. Thank you for taking my question. So my prior life, when I lived in Pittsburgh, Pennsylvania, I sold real estate for 17 years. And when I moved here and I put my license in an inactive status, I also put it in referral status so that all of the listings that I had in the pipeline per se, I would at least be able to compensate for some of the funds that I had put out. So I'm trying to find here where I do see, you know, making any referrals for commission, other compensation. Can you explain, wouldn't that be the same thing? So if you put your license in active status, is it the same thing as putting it in referral? Therefore, you would still be able to make a percentage of that? Because, I'm sorry.
Yeah, I'm unfamiliar with the referral, the referral part of this, and so I would have to defer to either Ann or the OPLC people to give you a definitive answer on that.
Okay, thank you. Representative Schmidt?
Thank you, Madam Chair. Calling your attention to page 2, line 1 strikes the word reciprocity and replaces it with recognition. Then later on on lines 3 and 4, it says, if already granted a license through reciprocity or recognition, those two handlings of the terminology seem to be inconsistent with each other. So are you redefining, you're replacing reciprocity with recognition in line 1 on page 2, but then you just add recognition later on. That doesn't seem to work to me.
Yes, once again, I will defer to someone who can give you a more definitive answer on that, and if it needs an amendment, we can do that, but we'll see what.
Okay, are there other questions for Representative Acton? Yes, Representative Legre.
Thank you. I've only had to lease a property once, and so my experience is limited, but when we did, we had to move out of state, and our real estate agents still perform services for us. For example, even when we had the same tenant, you know, the papers were delivered to me from our agent. If a repair needed to be made or the property needed to be inspected, in other words, our agent was providing a service for us, and that continuity existed. When you say inactive, are services still being provided? It sounds like no. Or is there no service being provided?
Well,
Thank you.
Thank you for the question. I basically, in this instance, when you go inactive, you're not allowed to do anything related to being a real estate agent. And so that you are no longer able to provide services such as that. But what we're talking about is if the agent who brings in the customer signs a lease, in the business agreement is that you get paid X amount for each renewed lease, then that can continue to be paid. Any ancillary services beyond that, based on law, you're not allowed to provide them as the inactive agent. But what we're trying to do is make it so that you can get paid on contractually of what you earned from bringing in people in signing leases.
Representative Schuett.
Thank you, Madam Chair. Representative, if you turn in your license, I'm seeing references here to other things that would continue, but I don't see specific reference to fees that are necessary if you remain licensed. would you still be paying fees?
When you go inactive, you have there's a set of rules that you follow to remain as an inactive status, but still in the system. Whereas if you let it lapse for, I believe, over a year, you are out. You have to actually retake the test to come back in. So this is inactive status is you're kind of a reserve, but you're not actively working in the business at that point. But you're kind of it's basically if a woman were to get pregnant or in my case become a state rep, you can't dedicate the time it takes to be an active active real estate agent, but you want to be able to go back to that in the future. So it's more of a temporary suspending of active status. You need to go inactive, but I'm still required to take CEU training and so forth to remain in the inactive status.
Follow-up question. So if you go inactive and you have exceeded the time for the fee that you've paid, those fees help pay for the education and so forth that you receive. So how are you covering that expense?
Well, I paid for the training myself. It's a private.
In most businesses, the professionals pay for the training themselves.
Okay.
And,
In some cases, some professions, the employer does, but in most of them, I think it's the own licensee's responsibility.
Thank you.
So there is a renewal fee and so forth. There are fees that we pay to OPLC to keep the inactive status alive. And then, like I said, I did have to take a fairly involved course that cost, I believe, $50 or $75 to stay on inactive status. So you don't just walk away from it and stay. You have to still keep within the system.
Other questions? Representative Marsh.
Yes, thank you, Dennis. It's good to see you again. Is there a procedure to go back on active status if you wanted to do that?
You have to reapply and re-enable your license, and you have to keep up with your training. That's the big thing. And if you don't do the training, then you can't do it. You got to go back out and start from scratch.
All right, follow up, Madam Chair. But if you've kept up with your training, it's a fairly straightforward process to go back to active.
Yes, and I'm on inactive. So I just took the class, and hopefully we'll go back to it as soon as I can. But it is easy, and it's actually, the OPLC real estate section was excellent. I feel the people are responsive. I quickly got my license. We've seen licensing problems in other areas, but I quickly got my license. There's a plethora of good courses to take all over the state, and I took mine remotely because of COVID, and so it's a very well-run section, and it's, I think, working very well for the real estate industry in New Hampshire.
Yep. Thank you.
Representative Schmidt.
Thank you, Madam Chair. I have a question for you regarding page 1 of the document, which seems to me to be defective again, looking at lines 20 and 21. You say, may apply for your New Hampshire license with the same equivalent status as currently licensed in the qualifying jurisdiction by first taking the New Hampshire portion of the licensing examination. And the word taking is used again subsequently, and I don't think that it does any good to take the exam unless you pass it. So why don't you just say passing the exam? You can't pass it without taking it, so
I think, Representative Schmidt, that's something that Mr. Shoemaker will be able to address better than Representative Acton.
That's correct. Thank you, Madam Chair.
Thank you.
It is a valid point, but,
Yes.
other questions for Representative Acton? No, then I will call, thank you for your testimony,
Thank
and I
you.
will call Mr. Shoemaker to explain all these details to us, briefly.
If I may, could Ann go first, and then I go after Ann?
If you like, certainly. Ann Flanagan?
Hi, my name's Ann Flanagan. I'm Jack Flanagan's sister. He originally introduced this bill before.
Please
co-
speak,
Oh,
come
I'm
up to
sorry.
the mic, please.
Can you hear me? Okay. My name's Ann Flanagan. Jack Flanagan's my brother. He originally introduced this bill when he was a representative. He decided not to run this time, so Representative Acton was good enough to do that for us. I used to be the investigator for the State of New Hampshire Real Estate Commission for 22 years. Retired, now I teach the classes. I think we were getting a little hung up on the whole rental thing here a few minutes ago, but the two key parts of that the first paragraph and the second paragraph are totally different, but the word on line 4 that was crossed out, receiving, and then later after that bracket, making. The way the law is currently worded, let's say you gave a referral for a listing or something like that while you were active, or rentals, but mostly selling, and then the way it's worded now, let's say you decide to go inactive or just let your license go or something like that and get into something else, you could not get paid for that referral or that listing or that buyer-client or lease or whatever you did the way it's currently worded. So by exchanging the word receiving to making, it just means if you're not active, then you cannot make any new business versus what this is, it is sort of housekeeping. It allows you to get paid for something you did while you were active. New Hampshire does not recognize, if you put your license in a referral, that's considered active in a referral division, as you were talking about before. So I think it is sort of just house cleaning. It allows, I guess you don't like that word or something, but I'm not sure. It does allow you to get paid for what you did while you were active, even if you are no longer active, or if you're working for another broker. They don't have to pay you through your new broker. They can just pay you directly for what work you did while you were active. Now, the second paragraph is more substantive. Whoever mentioned that about passing, that is a very good point rather than taking. Somebody had an issue on the second page, why it says reciprocity. Was that you? Yes. That's a good point, but I can explain it. The reason it still says the word reciprocity is because some people already got their license through reciprocity. So if we pass this, then there'll be people who get their license through recognition, but we already have people who got it through reciprocity. So if their out-of-state license that this was based on gets suspended or revoked, you need that in there. It needs to say reciprocity or recognition. You need both of them in there because you don't want to make it so that if they got it previously through reciprocity, that, they can go get their out-of-state license revoked and it won't affect their New Hampshire license.
Okay, so would it be fair to say that in the past we issued licenses by reciprocity, but now an out-of-state person would get a license by recognition?
Correct. There would no longer be reciprocity, only recognition. But as I just mentioned, you still have to deal with people who already have it through reciprocity. If their license out of state gets revoked, that would affect their New Hampshire license. If I had to make any suggestion on that second paragraph about the recognition, on line 27, it says non-resident salesperson or broker applicants. I would change that word non-resident to recognition applicants. The word non-resident, unfortunately, is one of those words that unfortunately has more than one meaning. The intent of the meaning here of non-resident is somebody who has an out-of-state license. But that word gets misinterpreted to mean they don't live in New Hampshire. So let's say they had a license in Massachusetts, they wanted to get their New Hampshire license, which is very, very common. Let's say they've already moved to New Hampshire. You don't want them to be denied recognition because of that, because what difference does it make? They have an active, good standing license in Massachusetts. What difference does it make if they get their New Hampshire license before they move or after they move to New Hampshire? it's just one of those words that has more than one meaning, and I've seen it get interpreted. You know, I would change the word non-resident to recognition salesperson and broker applicant. And I know I've talked to people at the OPLC, and they will talk about it as well. This is something that they're desperately wanting to happen because they spend so much time dealing with these out-of-state applicants who want to get a New Hampshire license. This would just make the whole process clean, uniform in nature, whereas now it's so subjective. I think that there's no reason not to pass this. Yes.
Thank you. Would you answer some questions?
Sure, I'd be glad to.
Representative Rhodes and then
Thank you, Madam Chairman. Okay, so I read this a little bit more after my prior question. So the previous speaker, the representative, spoke to basically what we all understand. You kind of put your license aside, you're busy doing other things. So is this saying that they are going to receive all of the commission compensation that was agreed to, even though they're actively not still maintaining and doing what needs to be done and another realtor is?
That's an excellent point, because most agents, when they actively work for a broker, have, as you know, an independent contractor agreement, and they vary. That independent contractor for one office may say, if you leave, you're getting nothing, okay? And you sign that, or you leave, you're getting nothing. But the more kinder, agent-friendly offices, their independent contractor agreement might say, if you leave, we will compensate you up to 6 months or a year or something from when you actually procured the action. But the problem with the law the way it's written now, let's say you had a big listing, $1 million listing, and for some reason you went inactive. Maybe you had medical problems, family issues, whatever. You decided to go inactive. And that $1 million listing that you brought into the office sells. And the broker says, oh, I can't pay you because you're no longer active. Well, why shouldn't you get paid for something you worked and did the work for while you were active? That's what this law is accomplishing.
Representative Schuett.
Thank you, Madam Chair. Ms. Flanagan, with reference to the change you suggested on line 27, would there be an instance that would apply that someone could have that previous term reciprocity also apply to that line? Should that be included in that language also, if we make that change?
No, because the purpose of this is to eliminate reciprocity going forward and go with recognition. So going forward, no, you don't want to let people apply for reciprocity.
So if someone were previously under that language of reciprocity, this would not apply to them?
Correct, because they already got their license through reciprocity.
Thank you.
I'm sure there's going to be a transition process through the real estate
Yes,
board.
thank you. Are there other questions from the committee?
Can I make one more point that I forgot to mention?
Yes, please.
The effective date, OPLC can probably talk better about this. This law is probably going to have some accompanying rules to it. You know, maybe some education requirements for these out-of-state applicants on the New Hampshire, specific regulations. I'm not sure how long the rulemaking process takes nowadays. I mean, is 60 days enough for that? Would 90 days be a better thing? I think they can speak to that better than I can.
We'll be sure to ask. All right, thank you for your testimony.
Okay.
Mr. Shoemaker?
Good morning, Madam Chair, members of the committee. For the record, my name is Joe Shoemaker. I'm the Division Director for Licensing and Board Administration at OPLC. I think Representative Acton and Ms. Flanagan did a good job. I don't know if there's much else I can add. I'll add a few things, but then happy to answer any questions you may have. Again, as was mentioned, this bill was brought forward last session, I think, or maybe it was the session before. and I think had full support. It really, I won't use the housekeeping language, I'll use loopholes, if you will. We get many requests on the two things that this bill does. The referral fees, just to clarify, Representative Rhodes, this doesn't mandate that companies pay those fees or commissions. It just allows them to. So again, it would still be agreement by agreement, but until now, unless this changes, they're not even allowed to do that under the current law. And again, we regularly have those questions come in to the OPLC through our customer service group, and fully support that change. Secondly, the questions around reciprocity versus recognition, I think Ms. Flanagan answered those well. One of the current challenges we have, we only had reciprocity agreements, from what I'm told, with about 4 states. I think it was Maine, Massachusetts, and a few New England states. In a couple of those instances, we don't have those agreements anymore. We just somehow, they were signed 20 years ago, previous to OPLC. We couldn't find them. We've gone back through meeting minutes and tried to, I think at one point we recognized that they'd been voted on in meeting minutes. So when we went back to a couple of those states, they really didn't have any interest in writing new agreements with us. So again, this just really going forward eliminates us having to work with states to come up with an agreement, and OPLC really supports portability of licensing overall, if you will, and this gets to that. We no longer have to come up with agreements. Again, if you are licensed in another state, we would recognize that license. The two things
Provided, of course, that you pass the New Hampshire
correct.
specific law part, which is unique.
Which is in here, correct. The two things that were brought up earlier, I would support the language change that was brought up from Representative Schmidt, adding in the language that they would need to pass the exam to be licensed. We'd have to look at it. I'm not opposed to having them start the application process as long as they tell us, but they wouldn't be able to be issued, obviously, until they pass that exam. The second one was Ms. Flanagan's comment about changing the non-resident language on line 27 on the first page. I'm fine with that too, changing that to license recognition, recognition. I think that's all I have. Again, happy to answer any questions anybody may have.
Thank you for your testimony. Representative Blekus has a question.
Previous speaker brought up the issue of effective date. Is 60 days all right?
Yes, well, I would prefer the 90 days. I had that in my notes. I was going to bring that up. Again, when this passes, we would do interim rules before we finalize, but I think the 90 days would be a little bit easier. So I'd prefer the 90, but if you prefer to stay with 60, we can work with that as well.
Okay, further question? As far as the recognition change, just to be clear on the language, would it just be replacing the word non-resident with recognition and that's it? Or would there be any other wording change required there? On line 27, page 1.
Yeah, I would say those recognized.
I mean, the sentence is,
Right,
this section applies to non-resident salesperson and broker applicants. Would it be, question is what exact wording would work there?
Representative Fellows?
So I think you can just cross out the word non-resident and the sentence will work fine.
Yes.
Okay.
There are many people in New England who have licenses from more than one state, not necessarily the one they live in, so.
Agreed. I think just removing it works.
Okay, great. Thank you.
Okay. Other questions? Thank you for your testimony. Is there anyone else who wishes to testify on House Bill 1354? Yes, sir.
Madam Chair, members of the committee, my name, again for the record, is Chris Norwood. I'm the 2022 Public Policy Chair for the New Hampshire Association of Realtors. And we support the bill. Much like the previous bill, I don't have a prepared written testimony, but certainly would ask anybody to answer any, or I'd be happy to answer any questions from a licensee's perspective. Specifically, on the upper section and the lower section, I think most of the questions have been answered. I think the only other item that I had in my notes is that there is currently a new makeup of the New Hampshire Real Estate Commission, and I don't believe the realtors have had a chance to connect with the current members of the Real Estate Commission, but it sounds like by Mr. Shoemaker's testimony that in general OPLC is supportive. So again, happy to answer any questions from a licensee's perspective.
Thank you for your testimony. Questions? Good timing on your part. All the questions have been answered. All right. Is there anyone else who wishes to testify?
Just a quick question, Madam Chair. You called yourself the 2022 policy...
The Public Policy Chair for the New Hampshire Association of Realtors, Representative.
Thank you.
Go ahead.
Thank you, Madam Chair.
Oh, thank you. Any other testimony? All right. I will close the public hearing on House Bill 1354. We will resume at 1 p.m. And this will be going to subcommittee for a fine-tooth comb on some of the language. Your bill is up first, so I'm recognizing you. Yes. House Bill 1182. I'm opening the public hearing and recognizing the prime sponsor, Representative Schmidt.
Good afternoon, Madam Chair. Oh, I got the volume turned up today. So I will be brief because we have OPLC people are here. And this is, as we've already experienced with a couple of other issues, this is something that the chair and I and some of the other senior members of EDNA have been working on because we think that the overall concept of management of boards can be improved by letting the experts at OPLC, experts in administration, law, the statutes, rules, and so forth, focus on their areas of expertise, and the stakeholders, the practitioners, will focus on their area of expertise, which is their particular profession, craft, or occupation. In this case, court reporters. And I'm a big fan, be quite candid and upfront. Excuse me. I'm a big fan of court reporters because, as some of you know, all of you should know, I'm on the jail car, and we have to have a very, very accurate record of our proceedings. And so for a long while, up until quite recently, we were assisted in every one of our hearings with a court reporter taking a verbatim, making a very verbatim transcript of our actual, our activities and our actual words. And I've looked at it, and they're much better than can be done by a tape recorder and a transcriber who wasn't there, doesn't know what's going on. So court reporters produce the best kind of record you can get that's reasonable without having, because even though the record that we are creating right now with our video cam and our words and so forth, you can go back and you can listen and hear the people say it as well as what they're saying, but you have to find the right spot and a printed document that you can analyze and so forth. So court reporters are a big deal. But I'm not going to get into the mechanics of the bill. You all can read. But what we are doing is letting the OPLC, as I say, play a greater role in the administrative end. They're not trying to take away the expertise of any profession. And we had the same situation a couple of weeks ago with one of our other experimental changes. And the executive director is here, Ms. Courtney, and she will talk about things from her end of things. So I'll take any questions you might have if you have any, but it's the fundamental theme of how we're doing it with a more focused application of the expertise on both sides of the issue.
Thank you, Representative Schmidt. Are there any questions from the committee? Representative Sytek.
Representative Schmidt, you mentioned crafts, occupations, and professions. Did you mean to exclude guilds?
Representative Sytek, you can't impugn his motives. Other
will only, I
questions?
will only say in response to that, that when I was living in Germany many years ago, I was acting as an interpreter for the OECD, not the OPLC, OECD, the Organization of Economic Cooperation and Development, and the word Innung came up. I knew German very well, but I'd never heard the word Innung before, and I didn't know what it was. And I found out it was the German word for guild, and a word
Thank
that
you
was somewhat out
for
of
the
use.
German lesson. Are there any other questions,
charge.
Representative Lakis?
Ordinarily, I charge big bucks for my German lessons.
Thank you. I mean, I'm looking at this, and I think it's the same as the existing statute, but the list of qualifications seem to be pretty general and have nothing directly to do with being a court reporter. Am I missing something here? Because it's...
No, this is for greater efficacy and efficiency of oversight of this particular board, and we Representative, what's your name again? Representative Goley, Representative Goley, Representative Schuett, Representative McGuire, and myself, as longer-serving members of OPLC, are doing this with a couple of small boards. We're not picking on any board. We're dealing with small boards, which have in some cases difficulties with quorums and so forth.
All right. My question was somewhat different. Thank you. I'll ask it separately.
Thank you.
Any other questions? Thank you very much, Representative Schmidt. Director Courtney?
Sorry. Thank you, Madam Chair, members of the committee. For the record, Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. Thank you, Representative Schmidt, for bringing this bill forward. OPLC is here today in support of House Bill 1182, which would essentially convert the Board of Court Reporters over to an advisory board. The basis for seeking out this legislative change is really just to come up with a solution with what we believe we've been having quorum issues with that particular board. As the committee is no doubt aware, the licensing boards have independent regulatory authority to promulgate rules, to issue licenses, and also to conduct discipline. And when a board lacks a quorum, they're unable to perform that regulatory function. The current Board of Court Reporters has 2 members. We lost a member, unfortunately, due to retirement or resignation back in August. And since that time, they've had 1 meeting. So we are concerned about the ability to make sure that their regulatory functions are continuously performed. And that's why we're here today in support of House Bill 1182. Happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Representative Schuett.
Thank you, Madam Chair. Just one. Is the membership called for in this board the same as the current membership?
I believe the membership is, there's a decrease in the number of individuals required. Our current advisory boards are comprised of 3 individuals, and typically a licensing board at least has 5.
And further question.
Follow up.
Do you have someone that you're looking at to fill the vacancy?
Not at the moment. Our understanding is that if this board were to be converted, all individuals would have to seek appointment under the new model.
Thank you.
Representative Fellows.
So I'm looking at the current statute, and it says that there are 5 members. So 3 are court reporters.
The other 2 are a lawyer and a public member.
Yeah, public, so.
Question, Representative Fellows?
I do have a question. Can you tell me what the qualifications are for a court reporter? Do they have to take any kind of a test?
So I do believe there is an examination, but I'm not intimately familiar with their requirements, which are established in rule, as you know.
Actually, they're in statute, Director Linda. There's 310A169 requires a registered professional reporter from the National Court Reporters Association or a certified voice reporter from the National Verbatim Reporters Association. So there's two professional organizations that they could be certified by.
Correct. And then there's always the requirements set forth in rules. You're correct, Representative McGuire.
Okay. Representative Goley?
Thank you, Madam Chair. I just want to go back to the makeup of the board and how this is going to be done from 5 members to 3 members and the time frame that's allowed, because we're hearing part of the problem is getting these people moved through governor and council. And if that is part of the issue, and we're starting over with new members and starting to set up a new board, looking at what the time frame is going to be for this to be set up.
Good. I think, Representative Goley, we might want to put in a transition clause that says the court reporters on the existing board are transferred to the advisory board to serve out their terms, because there's the same number of court reporters. But how many court reporters are actually serving on the board?
So there's 2 court reporters and there's 2 members of the board at the moment. There's only 70 licensed court reporters in the state right now. OPLC would certainly support an amendment that would include such transition language. We don't have any currently outstanding applications for court reporters to sit on the board. And my experience has been that generally if people can get us all of their information on time, we provide it to the governor's office as soon as we have all of the outstanding requirements.
Other questions? Representative Groden?
Thank you. Ms. Lindsay, so in this case, it's not a matter of the board necessarily meeting. It's an issue of the number of members on the board. Is that correct?
I think it's a combination of both. So we only have 2 members on the board, so that doesn't leave any wiggle room for somebody to not be able to attend for whatever reason. We need both of them to physically appear in order to conduct business. So obviously we are concerned about the ability to maintain a quorum with those numbers.
Thank you.
Representative Fellows?
Thank you. Do you know if there are any, off the top of your head, requirements for how often this board has to meet, and do they receive mileage?
All boards receive mileage. I do not know off the top of my head if there's a statutory requirement that they meet a certain number of times per year.
Other questions? Okay.
Thank you for your time.
Thank you very much. Yes, Representative Fellows has a follow-up.
Well, to answer my own question, because now I've found it, it says that they must hold at least 3 regular meetings per year.
Okay. Is there anyone else who wishes to testify on House Bill 1182? Obviously, the court reporters don't mind it. In that case, I'm going to close the public hearing on House Bill 1182, and I think I will send this to Representative Sytek's committee for transition language and looking and examining other language.
Good afternoon. 1:45, we will open the House hearing for House Bill 1466. Recognize Representative Schuett.
Thank you, Madam Chair.
1446,
Thank
my
you.
apology.
I was just going to say that. Good afternoon, fellow committee members. For the record, I'm Representative Schuett. I represent Merrimack 20, the towns of Pembroke and Chichester. And as Representative Schmidt had stated on the last bill, several boards were requested by the OPLC to become advisory because of their small size and the difficulty in obtaining quorums for meetings. So I undertook the first one to do the board governing recreational therapists, and Representative McGuire, who's listed as the co-sponsor, was originally going to do the respiratory care practitioners, and she suggested that since the two were so similar, we combine them in one. So that's why you see both professions and boards listed in the one bill. I did go through carefully, and as you can probably see, a lot of the language includes my favorite phrase, in consultation with the board, so that whenever the executive director of OPLC is considering educational qualifications, adopting rules particular to the profession, and things of that sort, she will need to go back to at least one member of the board, and so that they're aware of whatever is being requested. Other than that, I think it's pretty clear cut. And if you have any questions, I will try and answer them. But as you know, Ms. Courtney is here, and she's probably better qualified to answer any technical questions.
Are there any questions for the representative? Thank you very much, Representative Schuett. Ms. Robinson?
Good afternoon. My name is Debbie Robinson. I am a licensee of the Recreational Therapy Board, license number 002. I was a part of the original group that was seeking licensure for this profession, and what's been served on the original board. We are a small profession, but in need of this regulation, so I am pleased to see that there is an adaptation being made to allow for quorum so that activity can happen for the board, especially when there are instances of folks that are moving into town, into the state that need to practice, also new graduates that need this license to be able to practice their profession. And the lack of quorum lately has delayed action, so this is a way in which the executive director can act in order to have those that are practicing be able to do so lawfully and more rapidly.
Thank you very much. Representative Schmidt?
Thank you, Madam Chair. Welcome, Ms. Robinson. So is it your understanding that under the new arrangement, the practice of your profession will not be decided by the executive director, but rather in consultation with you with regard to how to modernize, update, or whatever it may be your profession, given national standards, changes, or whatever, and that you will be the source of that information, which the executive director will be implementing in association with you?
Thank you for the question. I don't currently serve on the board, but I have spoken to one of the board members because they don't work locally, and I was able to come to testify. And they are very much in favor of this. I also spoke to the National Office for Our Profession, who feels confident that this legislation only changes that the board would be advisory to the executive director, so that they would still have very good input related to our field and practice, but the activities of the board could still happen in consultation with the executive director, who I know and have full faith in.
Thank you.
You're welcome.
Representative Bailey?
I must be the only one in the room that doesn't know. Could you tell me what a recreational therapist
I'd be
is?
thrilled to. Thank you for asking. We are an allied health profession, sister professions to occupational therapy, physical therapy, speech therapy. We're often found in VA centers. We work in nursing homes with hospice. I work in mental health and have for my whole career. We also work in outpatient and inpatient physical rehabilitation. So just as an occupational or physical therapist would teach you to do the motor and fine motor and skills that you need to be able to regain your life, the recreational therapist would look at your passions and your enjoyments and how you can regain those pieces of yourself that are less, the things that people don't necessarily think of that need to be rehabilitated, but yet, if I told you you couldn't do the top 3 things that you enjoyed most in the world without adaptation and that they were gone to you as a result of your disability or injury, your life would be less. And so we would look at how do we make adaptations, how do we get a skier back on a mono ski or a sit ski so that they can have that still passion in their life even after an injury or illness.
Thank you.
You're welcome. Thank you for asking.
Representative Goley, did you have a question? No? Are there any?
We can make that happen for you.
Thank you very much, Ms. Robinson.
Thank you.
Director Courtney?
Good afternoon, Madam Chair, members of the committee. Lindsay Courtney, Executive Director, OPLC. OPLC is here in support of House Bill 1446, which seeks to convert the Recreational Therapy Governing Board and the Respiratory Care Practitioner Governing Board to advisory boards. Both of these boards have had significant issues with quorum. The Recreational Therapy Governing Board has not met since February of 2021, and the Respiratory Care Practitioner Governing Board has not met since March of 2021. And so as of right now, PLC is issuing licenses after 60 days by operation of law, again, without regard to whether or not they are actually qualified to do so. So we have some concerns, particularly as it relates to issuing licenses promptly and to individuals who qualify, but as well as to our inability at present to modify rules, as well as conduct disciplinary hearings if it's so necessary. This bill would allow the office to effectively communicate with advisory board members, and conduct the board's business, and alleviate some of the quorum problems that we've been having. So we urge your support of House Bill 1446, and with that, I'm happy to answer any questions.
Representative O'Brien?
Yes, this was a solid hand compared to Representative Gooley. Yes. Director, we heard on the other bill, I don't see it, but would there be a need any transitional amendment or anything else like that, or this one's pretty solid standalone?
I think we could certainly add the transitioning language to ensure that those who are currently on the board would be appointed on the new board. We could certainly do that. Some of the board members are, I would say for respiratory care, we have 2 in holdover of the 3 that are appointed. So it's possible that they don't even want to continue, that they haven't sought reappointment or they're not eligible for reappointment and they've just continued on. So that would be one thing that I think we would need to consider.
I think we can manage that. Thank you.
Representative Schmidt?
Thank you, Madam Chair. So let me ask you the converse of the question that I asked Ms. Robinson a moment ago. Is it my understanding correctly that it's not your intention under this new system to be taking over this profession or any profession, but rather to facilitate a better interaction of stakeholders and administrators in terms of expediting matters such as the quorum situation you're wrestling with at the moment with this board, but also to take away administrative things that are more of annoyance to board members and and time-consuming in areas where they frequently don't have any expertise, but that in issues of substance about the profession, that's where their advice would be your guide star. Is that my understanding correct?
Yes, thank you for the question, Representative. OPLC fully believes that licensed professionals need to provide need to be part of the decision-making process as to how that profession should be regulated. It's because those are the individuals who are best qualified to determine how to adequately protect the public from those who may not be competent to participate in that profession. So when we look at occupational licensing, there's the regulation of individuals in their practice, and then there's the administrative functions of that practice. And what we've found, obviously, is that the office, we're not experts in any particular field. We're not physicians. We're not recreational therapists. But we do strive, and we're getting better, to be experts in administrative law and administrative procedures and compliance with state statute and rules. And the individuals on the boards are experts in their field. And so we think that we have to essentially marry the two together in order to really have a harmonious relationship and ensure that we are regulating individuals in that profession in a way that protects the public, as well as ensure compliance with statutes and rules. And I think that this model accomplishes that. We can leverage the expertise of the individual board members without requiring them to get bogged down in the administrative process of necessarily having to come in all the time and go through, menial tasks, sitting around and choosing to, for example, review every part of continuing education if that's not what they like to do. This particular field, particularly with respiratory care, with COVID-19, we've seen some significant issues and challenges in terms of our board members being able to actually participate on these boards. They're just needed at their places of employment. And so this would allow them to provide that consultation, that feedback, and allow us to effectively ensure that government is functioning while at the same time leveraging their expertise.
Follow up? Thank you. So you're going on the record with regard to how you intend to administer this particular board and other boards under the new system. But there will come a time, perhaps in 20 or 30 years down the road, that when you may no longer be the executive director. So do you feel that this format is sufficiently straightforward that even another executive director, one perhaps without your intention, could be more, the czar of the board or boards? Because I know that's one of the things that some of the practitioners have talked with me about, their concern. What about the future when you're no longer the executive director?
Thank you. Yeah, I think government always has to have contingency plans. We have to be able to function. And for these particular boards, they're not functioning at the moment. So there's really no regulation happening, nothing going on with respect to these two fields, which I think is very concerning. At the same time, you need to have checks and balances. You need to make sure that that those with expertise are part of the solution. We've seen this model work here in New Hampshire. We currently have 4 advisory boards. It works well. With respect to body artists and massage therapists, we seek their expertise, their input, and then we ensure that we implement the rules and regulations. And that, I really think, is the checks and balance of any governmental regulation, is really the rulemaking process. We'd have to go through jail card. There would be opportunity for public comment. Certainly, if members of the profession did not agree with any of the rules that we would be proposing, we are certain that that you would hear about it.
Thank you.
Representative Goley?
Thank you, Madam Chair. And thank you for being here today, testifying and taking questions. I want to go back to boards that are having trouble meeting or aren't meeting currently, it being an issue. Have you received any explanation as to why they're not meeting? Is it because of COVID, because of quorums, because positions aren't filled, or all of the above? Because I just have a concern if we go to advisory for everything instead of addressing the real issue of why we're not having a quorum, is my concern. I mean, is there a way to solve the quorum problem?
So what I can tell you is that we've been proactive in seeking applications for qualified people to serve on the boards. We've done email blasts. I've engaged with a lot of the associations that we work with and have good relationships with to find qualified people. I am not aware of a consistent issue with applications being held and not put forth. We have observed is that certainly COVID has impacted board members, both from being uncomfortable with attending and physical presence, as well as the fact that we regulate, the healthcare professions. So there's a workforce shortage. We've heard from board members that they're having difficulties getting, time off from work to be able to come. And then I think for those that are just burnt out, this may not be something that that they can devote their time to. So I think it's personal to a lot of the individuals who have been serving on the boards. I think one thing the state could look at is the number of positions we have on boards. I think a lot of our boards are fairly large and maybe not what they need to be. And that's something that I think we could certainly consider. But I also think that this could certainly resolve part of the problem, but I think, there could be other solutions out there, to your point, Representative.
Follow-up?
And just one follow-up, is there also not a bill in the Senate that might address online or being able to remote access and have board meetings?
Yes, there is a bill. It's sponsored by Senator Khan. I think it was the committee, EDNA, voted ought to pass on consent. I forget the bill number, but I'm sure that'll be making its way over here. That would permit the licensing boards to operate remotely.
Follow-up, Representative Goley?
And might that help in addressing the issue, especially when we have small boards of 3 members that may be from all corners of the state trying to meet here in Concord instead of at an easier location?
I think that could address it. I'm not sure that it would resolve the issue with rec therapy or with respiratory care. I'd have to take that back and look at it. I know respiratory care has 3 members, 2 are in holdover. So I don't know if that would resolve the issues on these particular boards, but I think by and large that would help certainly with some of our boards and quorum issues, certainly.
Thank you.
Representative Fellows?
Thank you. So most board members, regular board members, are nominated by the governor and approved by the executive council. For these advisory boards, are the people going to apply to you for these positions? And are you already doing that with some of the boards, advisory boards?
Yeah, so we just modeled this after the existing advisory boards in which the agency makes the appointments. Presently, all positions, with the exception of, I think, guardian ad litem, that's just nominated by the governor or appointed by the governor. The majority of OPLC boards are GNC appointments.
I'm not sure that I understood. So for the advisory board, are the advisory boards different?
Yep.
And is the distinction that for advisory boards that you will appoint them, and for the regular boards, it goes through GNC? Is that correct or not?
Yep, that's correct. That's the existing model. So we would just utilize this model, that model.
Thank you.
Are there any for Representative Sytek?
How many recreational therapists are there?
There are, I thought I might be asked this question, so I wrote it down. 76 licensed recreational therapists, 670 licensed respiratory care practitioners as of the close of last fiscal year.
Following up on Representative O'Brien, it wasn't clear to me, is transitional language advisable here or not? You described the board was a little shaky, holdovers and that sort of thing, but do you need a completely new board, or are you going to transition?
I don't think we need a completely new board. The one concern I had with this bill is that it takes effect 60 days after passage, and right now, particularly for respiratory care, because we tend to get those more of those applications, we are not able to do anything with those applications for 60 days. So I would be inclined to recommend that if this bill were to pass, that it be effective immediately so that we can at least start to get these applications out the door and license these people. Because particularly for respiratory care, we're contacted by facilities, residential care facilities, long-term care facilities that are just in need of respiratory care practitioners because of COVID, and we can't license them in a timely fashion.
Follow up?
That's fine for getting your licenses out the door. The question that I have is, if you feel transitional language is advisable for these, you may be aware that I've already put one in your in basket. If you wouldn't mind putting a couple more in, that would be great.
Absolutely, I can do that, Representative.
Thank you.
Are there any further questions for the director? Thank you very much.
Thank you for your time.
Are there any members of the public that would like to testify for House Bill 1446? All right, I'll close the public hearing. Thank you.
Okay, good afternoon. It having reached 2:15, I'm going to open the hearing on House Bill 1460 and call Representative Yokela.
Thank you, Madam Chairman and members of the committee. My name is Representative Josh Yokela, representing Fremont, Danville, and Brentwood. I am here today to introduce HB 1416 about removing the 1460. Yeah, thank you. Relative to removing the age requirements from the occupational licenses statute. And I wanted to bring this to your attention, not really to discuss, some of the weird age requirements, like occupational therapists being able to be licensed at 17, but the massage therapists have to be 18, but a temporary massage therapist has to be 21. Those types of things I'm not going to be focusing on today. Today I would like to focus on just the idea that the government shouldn't be discriminating based on age. And if the people meet all the other qualifications, schooling and graduating, having a specific degree in the field or whatever the other requirements are in the RSA, that the age requirement shouldn't be a barrier on and of its own. Getting a license doesn't necessarily mean that you are able to get a job. There's still the practice, the issue of seeking employment, and if they plan to do the business themselves, they still have to, convince people to hire them. So the issue, really what we're discussing here, is whether or not, in addition to all the other requirements, that age should be one. And age obviously does not reflect maturity. It's just a number. And so there's also the issue of emancipation. When we just passed a new emancipation law not too long ago, and part of the emancipation statute says that if a person is emancipated, they have the right to obtain a license to operate equipment or perform a service. And so obviously all these emancipated people will be under 18, and so there is a conflict also between their right to be able to obtain a license to perform the service and the statutes, which may not allow for any exceptions for that, for their age. And so I'm happy to answer any questions.
Thank you, Representative Yokela. I've always been amused by the requirement that someone have a graduate degree in dentistry and be of at least 18 years of age. It's unlikely
Yes.
combination.
Right.
Okay, Representative Pearson and then O'Brien.
Thank you, Madam Chair. One of the things that is jumping off the page here with me involves some of the professions where humans touch other humans.
Like occupational therapists?
There's a bunch of them. So where my concerns lie here is that if we're talking about removing minimum age requirements, we're talking about the potential for someone who's not a legal adult to perform some of these functions. How does that work if litigation is entered into against someone who's not even a legal adult that's performing a practice in any one of these professions?
Thank you for the question. I think that I think the answer to that is one, they could be emancipated, as I just suggested, and those would follow the normal course. There's also the example that I already gave that occupational therapists are allowed to be licensed at 17. And so they are touching someone. And in my experience with occupational licenses or occupational therapists, they are, expected to be well versed in, the muscles and how to achieve a specific goal. Whereas like massage therapists, it's, I think, a little bit more about general relaxation and stuff like that for definitely someone that's at a spa or something like that. But as I also said, that there's, just because the license can be granted does not mean that they could be hired, right? You would still need to be hired by a specific place, and you would also want to, or if they brought their own practice, they would still need to be able to, hold the business license and all of those types of things. So I think that it would be, as it was suggested inside the fiscal note, this is very unlikely to increase the number of occupational licenses in New Hampshire. It would just be a sign that we're not going to discriminate based on it. Thank you for the question.
Representative O'Brien?
Thank you, Madam Chair. Thank you, Representative, for taking my question. In my previous life, before joining the fine people here in ED&A, I was on transportation. And would you believe that we do have driver's license for people who are not emancipated at that particular time? Yet, by recommendation of many groups, because of the mind of a young person isn't completely developed, they have what's called like a tier license. So there's certain hours of operation that they have to go through. There's certain, there's people that they cannot have in the front seat of the vehicle. There's a whole bunch of rules that apply to the young driver for their particular safety. And to also, too, would you believe that by motor vehicle law, emancipation does not start until the age of 18?
Thank you for the question. Being on Children and Family Law as my committee, I would believe that I hear a lot of arguments from people arguing that people the age of 13 should be able to change their sex, and people the age of 16 should be able to vote, and people over the age of 21 or up to the age of 21 shouldn't be punished for nonviolent crimes because their brain hasn't been formed. So I would believe that people choose all different kinds of evidence to support the fact that certain ages should not or should be able to decide. And it in my experience, it's not consistent.
Thank you, Madam Chair.
Okay, Representative Bailey?
Thank you. Maybe somewhat related, but can you be sued under age 18, or does it fall on your parents?
If you're emancipated or
Well, if
anyone?
let's say you're not. You just get one of these licenses and you're not emancipated and...
Your parents, I believe.
Yeah. So, isn't, follow-up, I guess, isn't that a bit of a problem? That this maybe
For
should
whom?
be, I mean, I like the concept, but wouldn't it have to be in conjunction with doing something about that?
Thank you for the question. So as I suggested before, I don't believe that this is going to dramatically increase or maybe even increase at all the number of people that are licensed because of the other qualifications that are necessary, like graduating college and those types of things would limit the number of people that would even meet the other qualifications. And so what you're suggesting, I believe, is not that, you know, someone might be able to get away with not having any consequences. It just may not be the person that if they were, let's say, if they were not 18 and they were a physical therapist now, and they got hired and they hurt someone, I think that we would be in the same situation that we could be in right now, and that the parents would be held liable and not the minor. And so I think that it's not that it would open up to the wild, wild west, and someone still being held accountable. And so I would say that would be enough. Yeah,
Thank you.
Wouldn't the employer be more likely to be liable?
Yes. Obviously the employer would be, if you hurt someone while you're employed, that employer is going to be the one sued and not you.
And a emancipated minor would have a lot of trouble setting up a business.
Right.
So
yes,
they would be an employee, I would imagine.
Right, and so they were, it's possible that they would be, able to get the license and maybe work as an apprentice under someone, but it's very unlikely that they're going to be able to perform the job under the age of 18, let's say. But that's not always, everything that we're talking about also. There is home inspectors can be 18, but the engineer that built it has to be 21, right? And so we're not just talking about people under the age of 18 and the issues that arises from that.
Thank you. Are there any other questions from the committee? Representative Fellows.
Thank you. It appears to me that this is a list of all the places where age is a requirement in licensing, not motor vehicle, but under the things that this committee hears about. And if that is true, I'm just wonder specifically if you gave any thought to the massage therapist in that area, because this committee has heard a lot about control of massage parlors, and in thinking of it from the perspective of protecting 16-year-olds from being massage therapists and the consequences should that happen.
Thank you for the question. As a young person, I did seek to eliminate the discrimination that I see in occupational licenses. So yes, this bill is focused on the occupational license requirement of age and not of any other anything outside of that scope. And I am obviously not on this committee, and so I'm not as aware of the desire to ensure that people under the age of 18 are not massage therapists. But I think that if the people are, qualified to be a massage therapist, then I don't think that you should be discriminating on that against them for that, for their age. Just like I wouldn't suggest that we discriminate against people that are older.
Representative Blackus.
Thank you. Wouldn't you think that if something inappropriate's going to go on in a massage therapist, which I assume is the concern, that in and of itself would be illegal, separate from the age of the person. And if the place is going to be operated with illegal activity going on, I'm not, would you expect that they'd be careful about making sure people are licensed, whatever their age?
Thank you for the question. I believe that, if a person is not breaking any law in their massage, then they should not be forbidden from doing that massage. And so I do believe that if there was nefarious actors, if they're breaking one law, I'm not sure that breaking a second law is a significant barrier to them.
Thank you.
Any further questions? Okay, thank you very much, Representative.
Thank you.
Is there anyone else who wishes to testify on House Bill 1460? Okay, seeing none, I'll close the public hearing.
Madam Chair,
Yes.
if I may have the committee's indulgence for just a few moments. I'm grateful for the fact that we can stream hearings and executive sessions when we are not present. As the committee's aware, I was not able to be here last Monday afternoon because I had a doctor's appointment. But I happened to hear a comment during the executive session on CACR 30, which kind of piqued my memory. One of the members of this committee stated that during the 2016 election, there had been over 11,000 one-day affidavits signed to enable people to be able to vote, and that over 8,000 of them did not meet the legal requirements after the fact. And that did not sit with what I remembered from those elections.
I thought that was ones where the Attorney General's or the Secretary of State sent a letter and these were not returned.
Well, I checked with the Secretary of State.
Excellent. And you have some correction for us?
Yes, I do. Assuming that the numbers that were quoted were affected from the totals that come to the 11,000 were for the section of votes from June through December, which would be the state primary and general elections. And according to a report that the Secretary of State's office sent to the Speaker of the House and the President of the Senate, the total number of votes that were objected to and not responded to properly was 1,238. Spread those over the 4 elections involved, and from what I was told by the Secretary of State's office, there are 310 polling places in the state. The average would be very small for the numbers that were not responded to.
Thank you for that information. That may have been mentioned during the executive session, but I don't think it influenced very many people's vote of the.
Well, I
on the
will say that
CCR.
the member did say that he was taking the numbers off the top of his head.
Yeah, well,
But I brought it up only because I think it should be corrected.
if it was in the minutes, I'm not sure that kind of number is in the minutes. But if you will give that data to our clerk, he will do the appropriate thing with it.
I certainly will. Thank you.
Okay. All right.
Madam Chair, I think, not that we're going to debate the last election, but where some of those numbers came from is in the state of New Hampshire. When you move here, you have a certain window in order to transfer your license to the state of New Hampshire. That number exceeded 5,000 people that registered to vote and failed to have their license transferred to the state of New Hampshire within 90 days. The reason the Secretaries of State office did not put that under the same category is because it did not jive with law at the time as far as the definition of residency, but it did jive under the DMV law. So that's where some of those numbers come from. And that's why they weren't pursued. But that number exceeded 5,000. So that's, that's the number, that's what it was
Yes.
most commonly referenced as to
There are
the definition of that.
lots of issues and lots of numbers and I think people remember different ones depending on their point of view. In any event, I want to thank you all for being here. We are meeting Monday Monday the 7th for our executive session. So far, I don't know of anyone who's not going to be here. Representative Goley, I trust you'll check with Representative Fontenot? Yes, he will be here. He will be here. All right, thank you. It'd be nice to see him again. Representative Schmidt, that's okay? There we go. We exec'd 3 bills yesterday and needed 4 committee reports. I only have 1. Thank you, Representative Sanson-Estaso. The others are not yet in. Those are the only open ones, and I'd appreciate getting them at your earliest convenience. And yeah. And for your information, this is the package that's given to state employees on the deferred compensation plan. It was asked for at the hearing, and the director brought them by today for your reading pleasure. Okay, anything, and I think we're done for today, unless somebody has something. Okay, thank you.
Yeah,
How many papers there?
well, I have to keep track of stuff for the Democratic Leader's Office.
Yeah, oh, God bless
So,
you. God bless you.
slipped in there and signed your name. Well, Windham was certainly a very, very curious situation. What happened there? But now the study showed there was that folding machine that created the impression that some of those people had voted for. Didn't seem like the guys that sitting here voted on other issues.
All good fun. All right, ladies, have a good one. See you Monday.
So, it looked like you were going to jump on your microphone.
I was.
This last one.
I'm just gonna miss it there.
Well, I mean, you know, it's gonna take you a couple of years just to get through some training. And as I said to Bill, you know, there are great geniuses like Mozart who are given what? What's it called, Young Sheldon and so forth?
Young Sheldon, right?
But I mean, literally, I mean, go on YouTube and see some of these 8-year-olds